Hello, check. Alright, hello. Hello, check. Alright. Is the audio okay?
Please, Lordship, Lordship, I beg to mention item number 18.
18.
Yes. Lordship, here in this matter, Your Lordship, I mentioned it on behalf of Advocate General. So, Your Lordship, because of the election to the Lok Sabha seat, Your Lordship, the cabinet could not sit. So, because of that, can you grant 4 weeks time, Your Lordship?
So where the petitioner? There are some urgency was found there in this case, probably.
Yes, yes.
So where is the, have you informed the petitioner?
No, Your Lordship has not.
So let the petitioner come, might come. We'll wait for some time.
Oh, Lordship, Lordship.
Okay.
Please, my lord.
Yes, Mr.
Lordship, beg to mention hearing item number 32 and 33. This matters, your lordship, if this can be adjourned,
You for a state.
yeah, I'm for the stay, your lordship.
I have
Since-
informed the petitioner.
Your lordship, I did not saw any one of them this morning. However, your lordship, because of
Okay.
the other part matter, it may consume the whole day.
Yes, of course.
So,
That I have seen.
so this item may not reach, your lordship.
Okay. So as prayed for by Mr. Angami, Lana Council for the respondent number.
I'm for the state respondent. my lord.
Lana-
There's no private respondent involved.
Okay, Lana Council for the state respondent. List this matter after
2 weeks, my lord.
2 weeks. Okay,
I'm deeply obliged, my lord.
yes,
My pleasure, Lordship.
yes.
Lordship, I beg to mention item number 11. I
Item
did the-
11.
Lordship, I'm here to receive instructions, so kindly grant me 3 weeks time.
So affidavit not yet filed, it appears.
I'm here to receive instruction, Lordship.
Receive instruction.
Lordship.
Okay. Miss
Ayala Engine.
Lana Council for the petitioner is present. Stop. Miss
Pichano
Lana Council for
for the state.
the state respondent prays for
3 weeks.
and
time.
is okay, granted 3 weeks more time to file to obtain instruction and to file affidavit.
Lordship.
Okay.
And Lordship, I also like to beg to mention item number 1 and 2. On behalf of S. Mary, let this matter be come up after 3 weeks.
Great. Who is for the petitioner? Petitioner might come. Have you informed the petitioner?
Lordship,
We'll adjourn, but
100%.
wait for some time. This is the first matter.
Lordship, Lordship.
Okay,
Lordship, item number 6 and 8.
6 and 8.
Lordship, I carry this matter after 1 week on behalf of Subung Chang.
6 and 8.
Lordship,
You're for
and for the state.
So, have you informed the petitioner?
And for the petitioner, Your Lordship.
Okay, you have any objection?
No objection.
So when do you want, you said?
After 1 week,
After 1 week.
Lordship.
Miss
Aratsla Kips.
Kips, Kips, Learned Counsel for the petitioner is present in both 6 and 8,
6, 7, 8.
6, 7
8.
and 8.
Yes.
Okay. Miss, you are for state, you are for?
Lordship, I'm for respondent number, private respondent number 783.
Okay.
And for the state on behalf of S.
Okay. Miss so and so, appearing on behalf of Mr.
S.
S. Young, Learned Counsel for the state. Respondents. Praise for
1 week.
listing this matter after a week. Okay. Miss
Mika Acharya, Lordship.
Vika is also present. Learned Counsel for the respondent number 5 is also present.
Respondent number 7, Lordship.
7.
7, yes, Lordship.
Okay.
In all the 3 items, Lordship. 6,
Okay.
7, and 8.
Is prayed for by the Learned Counsel for the state respondent list to which the Learned Counsel for the petitioner has no objection, comma, list this matter after
1 week.
1 week. Okay.
May I please, Lordship, I beg to mention item number 3.
3.
If this matter may be come up for admission hearing on Friday,
You are for?
I am for the petitioner, my lord.
Okay. Is prayed for by Miss Ratsulla Kips, na?
Yes, my lord.
Learned Counsel for the petitioner list this matter on Friday.
Yes, for admission hearing as a
for
fixed
admission
item.
hearing. Okay,
There's an interim, my lord.
stop, para. The interim order passed earlier shall continue till then.
Obliged, my lord.
May I please, Lordship?
Yes,
Lordship, I'd like to mention item number 26. Hearing item number 26. Lordship, I prayed that this matter be listed on 6th of May. It's a joint prayer, Lordship.
And for the appellant.
okay. On the joint prayer made by Mr. Muli. You are for petitioner,
For the appellant,
oh, sorry, appellant,
yes,
Mr.
W.R. Muli.
and Mr.
Sentilo
Learned Counsel for the respondent,
for the sole respondent
for the sole respondent, list this matter
on the 6th of May,
on 6th of May.
Monday.
Okay,
Much obliged.
May I please, your lordship?
yes,
I'd like to mention item number 27.
27.
Yes, your lordship.
Okay.
Your lordship, my senior has some personal difficulties today. So if the matter could be fixed on 18th June. Your lordship, we have taken
You're for the
consent
petitioner,
for the respondent number 1.
respondent. So who is for the petitioner?
Your lordship, I've taken the consent of the other party.
Taking consent, okay,
Yes, your
Miss
lordship. And so
Learned Counsel for appearing for the petitioner,
for the respondent 1,
correspondent
1.
number 1. On, with the consent of the Learned Counsel for the petitioner, praise for listing this matter after,
On June 18,
oh, okay, on June 18. The prayer is allowed, list this matter on June 18.
much
Okay.
obliged.
May I please, your lordship. Your lordship, I beg to mention item number 12 to 17. We have received our affidavit in opposition, so kindly grant us 3 weeks time to file a reply. Affidavit in reply.
So in the item 12, you have already filed affidavit. Okay,
Yes.
you want file reply.
Yes.
In all the 13, 14, 15, 16 also you have filed affidavit already.
Lordship. Yes,
Okay, you
lordship.
want to file reply.
Yes, lordship.
Okay. Miss
Berta Tep.
Learned Counsel for the petitioner, praise for in is allowed. How much time?
3 weeks time.
3 weeks time to file affidavit in reply to the affidavit filed by the state respondent staff. Miss
Ichalo.
is Learned Counsel for the state respondent is also present. Staff is great, comma, list is after 3 weeks.
3 weeks.
Okay,
May I please, lordship.
yes,
I beg to mention hearing item number 28.
28.
Yes, lordship. Lordship,
I pray this matter may come up on 13th of May,
When?
13th, 13 May,
Okay,
1-3.
Miss
Because or no?
Learned Counsel for the petitioner prays for listing this matter on
13
13,
May, yes, Lord.
30,
1-3.
13 May, 13 May. To which Mr. Hangami Learned Counsel for Learned State Council appearing on behalf of the state respondent has no objection. Stop. His prayed, list is accordingly on 13 May. Okay,
Lordship, there's an interim.
Hmm?
There's an interim.
interim.
Yes, Lordship.
The interim order passed earlier shall continue till the next date. Okay.
May it please your lordship, I'd
Yes.
like to mention item number 9.
Item 1,
9.
9. Yes,
Your lordship, I pray this matter come up after 2 weeks.
okay. Miss
Prince Okira.
Learned Counsel for the petitioner prays for listing this matter after 2 weeks. Miss
Pichano,
Learned
states.
Counsel for the state respondent is also present. Stop. As prayed, list this matter after 2 weeks. Okay.
May it please your lordship.
Yes.
Your lordship, I beg to mention item 1 and 2.
1 and
1 and 2.
2
behalf
for
of
the
the-
petitioner.
Yes, your lordship.
Okay. Miss, someone mentioned for the respondent also you mentioned
Yes, Lordship.
on the joint prayer made by,
So,
okay, joint prayer made by Miss
Only
Learned Counsel for the petitioner and Miss
Pichano,
Learned Counsel appearing on behalf of the state respondent, list this matter after
2 weeks, your lordship.
2 weeks. Okay,
Much obliged.
Yeah, please, lordship. Lordship, I beg to mention item number 4. Lordship.
therefore,
Yes, lordship. Lordship, I pray that this matter may come up on 14th of May, lordship. Since the leading counsel is from Gauhati and he has some difficulties today, your lordship.
okay. Mr. Medovero, Learned Counsel for the
Appellant.
appellant prays for listing this matter on 14th May,
Yes, lordship.
to which Mr. Jimomi, Learned PP has no objection. Stop. List the prayer is allowed. List this matter on 14th May. Okay.
Obliged, ma'am.
That is the lordship. Lordship, I beg to mention item number 5, lordship.
Yes.
So contain matter, lordship. Lordship, one for respondent number 2 and 3, lordship.
2 and
2 and 3, lordship.
okay.
So, if this matter can come up after 2 weeks.
Who is for the, have you informed the petitioner?
No.
So this will be first item, will pass order. Okay,
Lordship.
prayer will be allowed only.
No.
Hmm.
May I please your lordship?
Yes,
I beg to mention hearing item number 29, 30, 31. On behalf of my senior Mo Champion, let this matter be listed on 2nd May 2024.
No objection, ma'am.
okay, you are for
For the state.
for the state. Okay. Learned Counsel for the petitioner, Mr.
Dinoksham, on behalf of
Praise for listing this matter on
2nd May.
2nd May, to which Mr. Okay, yes, sir. Learned Counsel appearing on behalf of the state respondent, stop. Please prayed, list this matter on 2nd May. Okay,
Much
Much
obliged.
obliged.
yes.
May it please your lordship. Your
Yes.
lordship, I beg to mention item 34 on behalf of my senior, Mr. Gauhati. We pray that this matter come up after 2 weeks.
34,
Yes, hearing
your
item.
correspondent,
Yes.
for the petitioner, my lord.
okay. Miss,
Aratsla Gibbs,
Learned Counsel for the petitioner is present. Miss,
Atsikiri,
you're for,
respondent, on behalf of Gauhati CJC.
okay. Appearing on behalf of Mr. Yangarwati, Learned CGSC, prays for listing this matter after
2 weeks.
2 weeks. The prayer is allowed, list this matter after 2 weeks. Okay,
Obliged.
Lordship, item number 18, Your Lordship, the council has,
18,
yes.
okay,
Lordship, I've mentioned it on behalf of Advocate General.
Okay.
Because of the Lok Sabha election, the cabinet could not sit. So Lordship, he's asking for 4 weeks' time, Your Lordship.
Yeah.
To have a sitting, Your Lordship.
I have no say, Lordship.
Miss. Okay, that's it. You're appearing on behalf of, okay,
I'm
Okay.
appearing on behalf
appearing
of
on behalf of Advocate General, Nagaland, submits that due to the Lok Sabha parliamentary election, the state,
The cabinet could not sit, Your Lordship.
the
have a sitting,
cabinet could,
yes,
could not sit to
Yes.
discuss about the
Yeah, matter.
matter. And praise
But
for,
last time, Lordship, this matter need not be placed before the cabinet because the law is already the rules is already implemented since 2017. That
Yes.
was also placed before this honorable court as to what
But-
is the
but-
reason.
but why it's lingering actually? Because someone is, some, I think the employee are suffering. They have also been,
Yes.
I think,
No promotion,
Lordship,
no advertisement.
That is what I have been
how
instructed.
one section,
Yes, I've been.
the entire judicial
Lordship.
staffs will should suffer. I don't know what is the intention.
Can you grant 4 weeks' time because that's what I've been instructed that they would
Hmm.
have a sitting. Your
Because
Lordship.
I've seen the records that regularly they're seeking adjournment.
Yes,
And then since 2017, it's very difficult. Two of them have retired, I think. And then you see without governing, without the rules governing them being implemented, and it's very difficult. And then you say, why this? Huh? In all other state probably is implemented or it is under the high court only. So why?
Since
Huh?
I'm not in this case, Your Lordship,
Okay.
I don't know. That's what
Just
I've been instructed.
Pass the message. I think it's time that the state government should also think about
Lordship,
the person serving in the judicial side also.
Lordship.
Hmm.
in the state of Nagaland,
It's
Lok Sabha
only- it
election
seems-
already,
Only in the state of Nagaland it appears.
yes, already Lok Sabha election already held.
Hmm. No,
Where is the
even-
question of another one month
that
for
is-
cabinet seat?
That is okay, but then why it has to come up to this stage? Okay. Yeah. Praise for, what did I say now? Praise for? 4 weeks time, listing this matter after 4 weeks.
Lordship.
Praise for 4 weeks now. Praise for further 4 weeks time. Huh?
Even pensions are held. up.
Yes, that is why. There is some urgency, it appears. Huh. Okay, Mr. Oh, sir, Miss. Just a minute. Huh? Miss Judge Zimomi, Land Counsel for the petitioner, is present. Stop, huh? Is present by Ms. So on behalf of AG, list this matter after 4 weeks.
Lordship, like,
Okay.
For admission, item number 5.
May I please the Lordship? Lordship, here I'm for respondent number 2 and 3, Lordship. Lordship, the matter is placed before the MRC, Lordship. And we are waiting for the status and outcome of the MRC, Lordship.
Okay.
Manpower Rationalization Committee, Lordship, for creation of one supernumerary post. And that is, the status is still awaited, Lordship.
Mr. Jimome, Land Counsel for the respondent,
Respondent 2 and 3, Lordship,
2 and 3 submits that the matter has been placed
placed before the MRC,
before the MRC means
Manpower Rationalization Committee, Lordship,
Manpower Rationalization Committee.
for creation of one supernumerary post of carpentry,
Yes, for creation of one supernumerary
post of carpentry,
post of carpentry
Lordship,
in the carpentry in the department of
CAWD.
C,
CAWT.
WD, and what is your father?
Status is still award.
And the
Status.
status is still awaited. And pray for
3 weeks time.
listing this matter after 3 weeks.
Lordship.
Stop. Mr.
And for the petitioner,
Okay,
on
Learned
behalf
Coun-
of my senior,
okay, Learned Counsel. Mr. So-and-so appears on behalf of
my senior Mochame.
Mr. Muazzam is Mr. Muazzami. Stop. Is great. List this matter after 3 weeks.
Lordship.
Okay.
And also the chair.
For admission, item number 10.
No one appears on behalf of the parties. Stop. As per the record reveals that the respondent is yet to file affidavit. Stop. In absence of party, this matter stand adjourned. List this matter after 3 weeks. Okay.
For orders, item number 20.
Yes.
Well, Lordship, the respondent number 2 appeared on the previous occasion, Your Lordship. However,
Some. Put it up. No. Too much of some. Your respondent number?
respondent number 2, Your Lordship.
Hmm.
He made his appearance on the previous occasion. However, today he's absent, Your Lordship.
Even information we receive is he's supposed to seek time. So we've been waiting for him, but
Yes.
so may it be listed after 2 weeks, Lordship. After 1 week.
Mr. Medavirulana counsel for the petitioner is present. Mr. Angami. Your correspondent number,
1, Lordship. Still respected.
Dana PP. Praise for. So this is for what you are praying for?
Lordship, actually, state is not even main party here.
Yes, Lord.
The
Okay.
private respondents was supposed to seek time as per information received, but since he's not here, my prayer is to list it just after 1 week.
Okay,
Yes, 1 week.
listing this matter after
1 week. Lordship.
1 week. Stop. No? The respondent number 2. He appeared earlier.
Yes, Lordship.
So he has to actually file
Affidavit.
an affidavit incorporating some factum of such compromise. Compromise, okay.
Yes.
Okay. Land counsel for the respondent number 2. Earlier, prayed for time to file affidavit incorporating the factum of the compromise entered into by the parties.
Yes.
However, he is not present in the court today. Stop. Is prayed. List this matter after 2 weeks.
Obligement. Lordship, there's an interim, Lordship.
Hmm?
There's an interim, Lordship.
There is
Yes.
interim.
Yes, Lordship. It's
Stop.
a-
Para. The interim order passed earlier shall continue till the next date.
Obligement.
For hearing item numbers 21 to 24.
Yes, anything to be clarified here? So, yes, from the state side, it was to be submitted
Yes, yes.
for respondent.
For respondent, Your
Right.
Lordship, the petitioner has completed his submission. The
Yes, yes.
state, I was submitting on I have come to the special permit, Your Lordship.
Special permit granted to the land petitioner.
Yes, yes.
Yes.
To that I have submitted.
Yes,
Just to refresh, Your Lordship, I'll
Right,
just
right.
make a
Please,
short submission on that
please.
special permit again, Your Lordship.
Just-
So Your Lordship, as,
You have just a minute. Your file affidavit.
yes, yes,
Just a minute.
yes,
Let me have the affidavit first.
Lordship.
Private respondent has also filed affidavit. Yes.
Lordship, I was making a submission on WPC 88 of 2022. 88 of 2022.
This is 58,
Yes,
23, 88.
88, Your Lordship.
Okay.
Because they, as the parties have already submitted, the main crux of the case is at 88 of 2023.
88.
Yes, Your Lordship. If this is decided, then the other two writ petitions will automatically get covered, my lord.
Right. Just a minute.
Lord.
Your affidavit is. Your for respondent 1, 2, 3, and 4.
Correct, my lord.
Yes. So. Yes.
May I start, my lord?
Yes, please.
Lordship, as stated,
Hmm.
there was a special permit granted to the petitioner's father
Yes.
by the government of Nagaland, via the permit dated 29th of March, 1971.
Yes.
Lordship, this special permit, your lordship will find it at page 31 of the writ petition.
Yes.
Now, your lordship, as I was submitting, the special permit
Yes.
the special permit, your lordship, was granted to the petitioner's father for a particular purpose. And this is not what I'm submitting, but this is what the petition, the special permit clearly states. As the permit, your lordship, if my lord has found the page 31. Page 31 of the writ petition, my lord.
Yes.
It says special permit for farmland at Tijit. So the permit was for farmland at Tijit, your lordship. And it says, Sri such and such is allowed to continue cultivation of the low-lying areas which he has already put under paddy cultivation at Tijit. The line of demarcation will be as follows. So the special permit, your lordship, was granted to the petitioner's father for a particular purpose, and that is to cultivate the area which was demarcated in the special permit itself. Now, your lordship, in the body, the demarcation, the proposed demarcation is mentioned in the body, which starts with a straight line will be drawn from the point on Sonari Mount Road as shown in the survey map till it joins another survey mark near the private track as shown in the survey map. From the survey map, it will run straight south till the line reaches the first line of banana tree after each which it will turn straight northwest till it comes parallel to the point marked on the stamp by me on 24/5/1971. Your Lordship, the type copy, Your Lordship will find on the next page. The type copy of this. Yes, which is legible, Your Lordship,
Yes.
the type copy.
Mhm.
May I continue, my lord?
Yes, please.
Taking the last point of northwest line, a straight line should be drawn towards south, crossing the marked stamp till it reaches another mark on the dead tree. From this dead tree, a line will continue straight for a few yards, then turn southeast and now join the tuned area. Following the area already joined this year, a line should join Digit near the river, near the pool called Chizax. Your Lordship, the next line is important. Besides this area, he is also allowed to continue paddy cultivations at the confluence of Digit and as being shown in the map and it ends with, besides these two areas, he should vacate all the areas he has put under cultivations immediately. So this special permit was was issued to the petitioner's father for the very purpose of cultivation. And it says, besides the area that is mentioned in the special permit, he shall vacate all other areas he has put under cultivation. That means, Your Lordship, the petitioner's father was cultivating a huge portion of the land belonging to the government. And by this special permit, a map was drawn, a demarcation was made for him to cultivate only that portion of the land which is demarcated in the special permit. And therefore the line, Your Lordship, besides these two areas, he shall vacate all areas he has put under cultivation. He has put under cultivation, Your Lordship.
Can you make out this area from the map?
No, Your Lordship.
No.
No, it is in fact very difficult.
Yes,
Yes. But
it's approximate.
yes,
approximately.
yes,
Your Lordship, the map, there is a box in the map, that is the extent of the area. which
The
was
box is also in the
Yeah, this is the.
made by the authority only.
Yes, this is prepared by the authority.
Straight, from the box, we could see that it is a straight one.
Yeah, one goes from east to west. One, and then it is box which is not not a rectangle also, but it is specified. This is the box.
And then can you just make out from out of this box, the present land involved with the dispute, all is 100 plus and all
Yes,
are within this box.
yes.
it should be,
Okay,
should be within this area.
okay.
That the special permit that was granted also comes with an area. So the dispute is within this area, not beyond that.
Yes.
Not beyond that.
Okay. So, but then, so this is specific, beside these two area,
Yes,
he should vacate all whether this straight line is the two areas. Whether this straight line,
yes,
this line covered,
yes,
the box under, within
Yes.
this box under,
Yes.
within this box is comes under these two areas.
Yes,
it should be like that, Your Lordship.
Okay.
Yes,
Yes.
yes,
It is not dispute.
yes, we may consider that, Your Lordship.
Okay, okay,
We may consider that,
okay.
yes.
So then
Since,
it comes.
yes, since there is no specific demarcation except
and-
this line.
and probably there is no complaint that he has not vacated
Yes,
rest of the areas
he has already vacated.
already vacated.
Yes, there is
earlier.
no issue about that. Only that area which was
Okay,
was
okay, then,
allocated,
Yeah,
we are concerned with that.
yes, Your Lordship.
Okay,
I agree with my learned friend here, Your Lordship. The other areas are not in dispute.
okay.
Only that area
Hmm.
which is covered by the special permit.
Yes, yes,
That's the only thing.
right. Okay, okay.
Now, Your Lordship, as the special permit was only granted for a particular purpose for cultivation,
Hmm.
Your Lordship,
Hmm.
it is not an allotment in any sense, Your Lordship. It is just a permit to cultivate. Now, what happened, Your Lordship, after this?
Hmm.
The petitioner, on the strength of this special permit granted to his father, has submitted a representation before the then Chief Secretary of the State of Nagaland, alleging that there was an encroachment going on his land, Your Lordship. And the Chief Secretary, on receipt of such a representation from the petitioner, has issued a letter dated 18/7/1996, directing the Deputy Commissioner Mon to conduct a special inquiry and to submit its report. Your Lordship will find the Chief Secretary's letter 18/7/1996 at page 40 of the read. Page 40 and make sure F of the read petition, Your Lordship.
40.
40, my lord.
Is the, okay, this is the letter of,
The Chief Secretary of the then Chief Secretary to the Government of Nagaland.
okay, the type
To
copy
the-
is, type copy is 42.
Yes, the type copy is a 42.
Okay.
To the Deputy Commissioner Mon.
Hmm. Yes,
Now, Your Lordship, the specific direction that was given to the Deputy Commissioner Mon, Your Lordship will find it at page 41, which says,
Hmm.
you are hereby asked to conduct a special inquiry and submit detailed report. Comment as early as possible. So this was the direction
Hmm.
issued by the then Chief Secretary to the State of Nagaland to the Deputy Commissioner Mon to conduct a special inquiry and to submit the report.
To DC Mon.
Mon, to DC Mon.
Cool.
Because the place, Your Lordship,
Hmm.
where the dispute is under the ABC Digit, which falls under the district of Mon. Therefore, the DC, Deputy Commissioner Mon, is the person who heads the administrative head of the department in the district. And therefore, the direction was given to the Deputy Commissioner Mon to conduct a special inquiry and to submit its report.
Hmm.
Your Lordship,
Yes.
after this, Your Lordship,
Hmm.
the petitioner approached this honorable court
Hmm.
by filing a writ petition, WPC 204K of 2012. And this writ petition, Your Lordship, was disposed of by this honorable court through its judgment and order dated 5/8/2014. Your Lordship will find the judgment of this honorable court dated 5/8/2014 at page 50. Page 50 of this writ petition, Your Lordship.
Yes.
Now, Your Lordship, while disposing of this writ petition 204K of 2012, this honorable court has given a specific direction. And Your Lordship will find the relevant order at page 53.
Hmm.
To save time, Your Lordship, I will straight away start with the line that starts with the fact. Page 53,
Yes.
the fact, Your Lordship.
Hmm.
The fact as to, if I may be allowed to read, my lord.
Yes, please.
The fact as to issuance of direction by the Chief Secretary is also not in dispute. This being the position, I feel inclined to allow these writ petitions and direct the Deputy Commissioner Mount to hold special inquiry as was directed by the Chief Secretary by an order dated 18/7/1996. within a period of 3 months from the date of receipt of a certified copy of this order without fail, and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass necessary final orders within 2 months thereafter from the date of the receipt of inquiry report from the Deputy Commissioner Mon. Now, why such a direction was given in this judgment and order is for the fact that the petitioner, when in the WPC 204K of 2014, has stated that in spite of the representation submitted to the Chief Secretary and the Chief Secretary issuing a letter to the Deputy Commissioner Mon to conduct a special inquiry, that was not done. And therefore, this court has directed that the Deputy Commissioner Mon should hold the special inquiry as directed by the Chief Secretary, and thereafter a report shall be submitted to the Chief Secretary, when the Chief Secretary shall take a final decision thereafter. This was the direction passed by the Honorable Court in its judgment and order passed in WPC 204K of 2012.
Yes.
Now, Your Lordship, after this, in compliance to this judgment and order dated 5/8/2014, passed in WPC 204 of 2012, Your Lordship, a special inquiry committee was constituted. Now, Your Lordship, the report of the inquiry committee, Your Lordship, will find it at page 55.
Yes.
Now here, Your Lordship.
Yes.
Lordship, this special inquiry committee was constituted by making the ADC Tijit, Additional Deputy Commissioner Tijit, as its chairman, and SGO Civil Mond, PA to DC Mond, LRSO, this means Land Record Survey Officer Mond, and Head DB Dubashi Tijit as its members. Now, this committee was constituted in compliance to the judgment and order passed by this Honorable Court. Now, Your Lordship, here, the background that was taken into consideration by the special committee report, by the special committee, Your Lordship, I will just refer to the relevant para only.
Yes.
Background, the first background, the first para. It says, in 1971, at
Yes.
page 55,
Yes.
in 1971, the then DC Mon issued a special permit to late Wanshu, this is the name of the petitioner's father,
Yes.
as farmland. Here also it is mentioned as farmland. In recognition of his service to the government and the people via of his memo that such and such dated 29th of March, 1971. In 1974, Sri late L. Wanshu died and the special permission passed on to Sri Nogman Wanshu, this is the petitioner, the eldest son of L. Wanshu. Sri Nogman Wanshu alleges that despite having documentary evidence, the General Administration has several times encroached upon his legally inherited farmland by way of issuing permit without his consent. In the same manner, in course of time, government departments, including industries, other private individuals were granted permit by the General Administration. The next page, my lord.
Yes.
As a background to this case, it is to be noted that the land for Pijit Township was donated by the Jaboka village measuring 1,200 acres. The donations was made to the government by the village, free of course, without any terms and conditions, which was agreed verbally. This farmland also falls within the area donated by the Jaboka village. Now, Your Lordship, the next para is about the map and the area. So, Your Lordship, I'll try to avoid that. But, Your Lordship, I would like to take my note to a particular sentence in this para, starting from 6 lines from the bottom. That starts with even. 6 lines from the bottom.
Yes.
that starts with even.
Yes.
May I read, your lordship?
Yes, please.
Even Sri Nogman, during his meeting with the committee on 24/10/2014, admitted that he has no knowledge of the exact boundaries as contained in the permit. Your lordship.
Yes.
Now the next para, your lordship. On cross-examinations of the office records, on the issue of permits, it has been found that in various stages and officers at Digits, permits were issued by the authority concerned in the name of expansions of the town to cater to the ever-increasing needs of the fast populating town. Government departments, industries, and other public utility was set up by the government purely to meet the increasing needs of the town. All the above government department utility services are functioning today at Digit. Now, your lordship, the next paragraph. On physical verification, it was found that the district administration during tenures of the officers have issued 11 notes of permit from 1988 till date. During inquiry, it is also found that the complainant, Sri Nogman, on his own capacity, has been selling out plot of lands to private individuals at substantial rates without the consent and informations of the government. On further inquiry, it is also found that the vast tracts of land has already been allotted, given away free of cost to several private individuals on several locations. It has also been revealed that the Sri Nogman, taking full advantage of the privilege given by the government to his father for a farmland, has sold out plots to 12 identified individuals by taking a substantial amount of money and later permit acquired by these donnees from the ATC office, Digit. Furthermore, due to this uncompromising stance between government and movement, several individuals taking advantage of the situations has been occupied in more than 17 locations, plots without any sanctions from the government. Now, your lordship, committee findings. I will read only committee findings of para 1, 2, 3, and 4, your lordship. 1. The first finding. The special permit issued in 1971, void memo number such and such, dated 29th March 1971, issued by the then ADC Mon, is authentic. However, there is no record of payment of revenue to the government, and the permit does not stipulate any terms and conditions governing the special permit. Number 2, it is an accepted fact that the land for Digit headquarter town was donated by the Jaboka village to the government, and the special permit itself was issued to late L. Wanshu by the government. In view of the rapidly growing populations of Digit town, the district administration needs more land for development of the town to appease the growing needs of the land for dwelling units. The district administration has issued permit for the purpose of expansion and development of the town. 3. There are already 111 notes of permit issued by district administration from 1988 till date. Further, 12 notes of plot was settled through the complainant and 17 notes without any permission, adding up to 140 families already settled in the area. Trying to relocate these 140 odd families will create a lot of social tensions, leading to a grievous law and order problems in the town. Number 4, your lordship, the committee is of the view that to bring an immediate and amicable settlement to this issue, an alternative arrangement may be offered to Sri Nogman Banshu by offering him 200 to 300 square feet of land presently occupied by him, and also in recognition of the services rendered by his father, late L. Banshu, either a school or a public hall in the locality be named after him. And the last one, it says, further, during the course of inquiry, the Special Inquiry Committee have received a complaint letter from the Village Council Jaboka, which are made available to you in original, as the committee has no legal obligations in replying to this complaint.
The committee received the complaint letter from the,
Jaboka village. These are the real land owners, Your Lordship, who have donated the land to the government for the establishment of Digit headquarters.
yes.
Now, Your Lordship,
Hmm.
on perusal of this special inquiry committee report,
Hmm,
certain things, Your Lordship, becomes very clear.
hmm.
And I would like to highlight those things, Your Lordship, before this honorable court. First, Your Lordship, the land
Hmm.
or the area of land that was given to the petitioner's father through the special permit falls within the area or the land which was donated by the Jaboka villagers to the government free of cost for the establishment of the Digit headquarters. Now, Your Lordship, the petitioner in the entire writ petition has never disputed these facts, that the land was donated to the government by the Jaboka villagers and the area of land that was given to the petitioner's father for cultivation through the special permit falls within that area which was donated to the government.
Hmm.
So, not disputing this is an admitted fact that, Your Lordship, the land in question in its entirety was donated by the Jaboka villagers to the government. Now, Your Lordship, lands were re-allotted to various government departments and industries and other public utilities set up to meet the increasing need of the Digit town. Not only that, Your Lordship, another fact that has come out was that the petitioner has been selling plots of land to private individuals at an exorbitant rate. And also several tracts of land was already allotted by him, as well as given away free of cost to private individuals without consent and permissions of the government.
Hmm.
Now, these facts on the face of the inquiry committee itself, report itself is very clear. Now, Your Lordship, this inquiry committee submitted its report to the Deputy Commissioner via letter dated 31/10/2014.
Hmm.
Your Lordship, the inquiry committee
Hmm.
has submitted its report to the Deputy Commissioner Mont via letter dated 31/10/2014. Your Lordship will find the letter at page 54 of the writ petition.
Yes. Hmm.
Subsequently, Your Lordship,
Hmm.
the Deputy Commissioner has by a letter dated 14th of November 2014 submit the inquiry report to the Additional Chief Secretary and Commissioner Nagaland. Your Lordship will find the letter dated 14th November 2014 at page 64. Page 64, Your Lordship. If I may be allowed to read just the subject, Your Lordship.
Yes.
to the additional chief secretary and commissioner Nagaland, subject submissions of special inquiry report, references WPC 204K of 2012, Sri Nogment L. Nogment Konyak versus State of Nagaland and others. So the inquiry committee report was submitted by the deputy commissioner to the government through his letter dated 14th of November 2014.
Same report.
Same report, Your Lordship, because it has to be forwarded to the government
No,
for
no,
taking
so
for taking a
earlier,
decision.
The report was submitted before the chief secretary.
No, the report was submitted to the deputy commissioner,
Sorry, deputy commissioner. So
Yes.
deputy commissioner submitted before the,
the additional chief secretary
chief secretary.
and commissioner.
okay.
Now, Your Lordship.
Hmm.
Before any decision was taken on the special inquiry committee report by the government, Your Lordship, several rounds of talks was held by the government with the petitioner. And Your Lordship will find that the petitioner has put certain conditions even in the talks that was held with him by the government. Your Lordship will find the report of those meetings held with the petitioner on dated 10/7/2015 as well as on 31/7/2015 at page 67. Page 67 of the writ petition, my lord.
This is not a separate annexure.
Yeah, this is a separate annexure. This is a special report held on a separate date.
This is annexure.
Annexure, Your Lordship, this is annexure L.
L is submission of a special inquiry report only.
Oh, Your Lordship, this special inquiry meeting held on 10/7/2015 and 31/7/2015 was sent to the deputy commissioner through this letter, that is annexure L. Your Lordship will find in the body of that letter.
Okay, that means the submission of special inquiry report.
Yes.
Is page 66 only.
No, this is not inquiry report, Your Lordship.
Then why,
Yeah, this is a meeting held with the petitioner after the inquiry committee has submitted the report and before the decision was taken by the government.
okay, no, this was submitted by this report,
Yes.
page 66.
Yes,
Now just see page 66.
yes.
Is this the forwarding letter?
Oh,
Okay, so
No.
this is not connected.
no, this is not connected. This was what happened was, Your Lordship. The inquiry committee has submitted its report to the deputy commissioner.
But you referred, because you referred
Yes,
annexure L.
in annexure L.
Annexure L is different.
Annexure is totally different, Your Lordship.
Yes, L.
Annexure L, I was submitting
Hmm.
on annexure L that before the government take a decision
Hmm.
on the committee report,
Hmm.
on the special inquiry committee report,
Hmm.
several rounds of talks was held with the petitioner by the government. And these are the reports of the meeting held with the petitioner by the government. If I might be allowed to read the letter body part, Your Lordship,
Yes, sir.
it will make things clear.
Yes, please.
Sir, with reference to the subject cited and reference indicated above by letter number such and such dated 13/3/2014, I have the honor to submit herewith the report regarding the inquiry decisions and meeting. Yeah, inquiry decision and meeting held with Sri L. Nogman, which was held on two occasions, that is 10/7/2015 and 31/7/2015 for your further necessary action. So before the inquiry committee reports, a decision was taken by the government. Again, several rounds of talks was held with the petitioner because the petitioner was not satisfied with the inquiry, special inquiry report.
So this is,
So page 67 is the meeting minutes
And then 66 is the forwarding letter.
It's a forwarding letter. What transpired in a meeting was forwarded to the deputy commissioner by the ADC Digit.
Hmm.
I may be allowed to read
Yes, please.
the meeting minutes.
Yes, please.
Page 67, my lord. A report of the meeting held with Sri Lokman Wanshu, son of late L. Wanshu, in connection with the special land permit dispute related to WPC such and such is Lokman Wanshu versus State of Nagaland. Yes,
Yeah, you
page
read
67, my lord.
67, yes.
Yes. It starts with the subdivisional administration, if my lord has got it.
Okay, yes, sir.
The subdivisional administration, as directed by the DC Mount, held a meeting with Sri Wangshu, Nogman Wangshu on 10/7/2015, and also on 31/7/2015 in the office chambers of the additional deputy commissioner Tijit, with a view to sort out the outstanding issues regarding the allotment of land. Now, your lordship here. The next line. During the meeting, certain contentious point, demands, and proposal submitted by Sri Nokman was discussed primarily. Points by points discussions were given as unders. One. Now, these are the demands forwarded by the petitioner in the meeting.
Yes.
Demand number one, resurvey of the special permit as per 1971, but not as per 1975. Now, what was discussed, your lordship? Resurvey of the special permit had already been carried out on 27/10/2014 with the help of a retired Dubashi Sri Auchok and Mr. Zenai Konak, caretaker of Sri Nogman, as these two individuals were present in the spot physically during the 1975 resurvey of the 1971 special permit. The areas as per survey done on 27/10/2014 with GPS measures 157.81 acres. Since the exact boundary pillar could not be traced as written in the special permit of 1971, the subdivisional administration proposed that the resurvey done in 1975 by Sri Atrok retired DB and Mr. Zenai caretaker, which is again resurveyed on 27/10/2014, along with the above two individuals to be taken as the actual extent of the area. Twenty-seven 10/2014, your lordship. Now, the demand number two, your lordship, that was placed by the petitioner was release of compensation from old household already settled via permit issued by the administration within the jurisdiction. It was discussed in the course of development of Tijit town, the need to cater to ever increasing population necessitated the administration to issue permit to meet the expansion of the town during various stages and of officers at Tijit. On verification, it is found that the district administration has issued 111 notes of permit from 1988 till date. It is also found that the complainant also in his own capacity has been selling, allotting plots of land to private individuals without the consent and approvals of the government. In this connection, the district administration has received representation from Tijit Town Public Union, the Jaboka Village Union, actual land donors, seeking clarifications and complaint against allotment of huge acres of land to a single individuals as it is threat to their existence and development activities to Tijit Town in the near future. As such, considering to this demand will create law and order problems at Digit Town.
This, the public
Yes,
or the original
landowners.
donors
Yes.
has raised this question only in the year
No, before, long before that,
long before,
long before that,
Hmm?
long before that.
long before.
Yes,
Say around which year?
Lordship, to answer that, Your Lordship, if my lord can kindly come to para 6 of the writ petition.
There are 6 of.
Writ petition.
Okay.
This is the petitioner's own statement. The subsequently again in 1981, some individuals from Jabaka village have raised an issue before the administration that the Jabaka village has offered 1,200 acres of land on compensation basis to the administration for establishment of Digit headquarters, and that the petitioner's farmland also falls within the land offered by the village. The then subdivision officer intimated the petitioner to submit supporting documents, and the petitioner having produced the required document, the said officer's white letter dated 18/7/1981 inter alia requested the deputy commissioner Mount to clarify the petitioner's case, since the permit in favor of the petitioner's father was issued from Mon office. However, no clarification whatsoever was issued by the office of DC Mon in pursuance of the SDO civil letter dated 18/7/1981. So this has been long before the inquiry has
81.
started. Long before that, Your Lordship. Now, demand number 3, if I may be allowed. Back to page 67, my lord.
Yeah.
Restorations of all vacant plots area to me falling within the special permit. This is demand number 3.
So this demand means demand of the petitioner.
Yes.
Okay.
Subdivisional administration offered, Your Lordship. And this is what the government offered. The subdivisional administration offered to allot all vacant plots that exist within the survey map down on 27/10/2014. To the complainant, if he agrees to relinquish his claim over the site allotted by the administration, the complainant did not agree to the offer made by this office.
To allot.
Yes. All the vacant plot that existed within the survey map as done on 27/10/2014.
Okay. That means the petitioner claim backs the land allotted by the government,
Yes,
claiming that this falls under his land.
yes,
Now the offer
yes,
is that leave this already allotted land
yes,
allotted by the government,
yes.
and then the rest of the area,
The vacant.
vacant area
Yeah,
will be given to him.
yes.
Allotted to him.
Which he declined,
He declined.
which he declined.
Hmm.
Number 4. Next page, my lord.
Yes.
This is demand number 4, to recognize the said area of land as L. Wanshu Konyak colony in memory of my late father. This is demand number 4 by the petitioner.
Hmm.
And the district administration agreed in principle to forward for recognitions and renaming represent industry land to L. Wanshu colony as and when differences are settled. Number 5, demand number 5, to stop issue of fresh permit without my consent prior to 1971 special permit. With the standing order of the Gauhati High Court not to issue any permit, but in respect of the petitioner, it was agreed not to issue any fresh permit from both sides until judgment is finalized. The petitioner also verbally agreed to take responsibility for any issue arising out from the sites, plot allotted or sold from his site. Demand number 6, to stop all double permit holders at present trying to enter within my jurisdiction. The administration, this office will look into the matter if such cases arise. And demand number 7, list of names permit holders issued by the district administration within the jurisdiction under the special permit since 1971. The list has already been furnished but to the applicants, and the list permit allotted from the applicant's site has also been received. So that's why has been allotting permit, your lordship. Number 8, it is requested for final judgment of the Honorable High Court since the case is lying in the court. Both the parties agreed to wait for an early and amicable settlement by the High Court, by Honorable High Court, your lordship. So this was the demand in a meeting, which some, your lordship, which was possible on the side of the government, was agreed upon. And the thing that was offered to the petitioner declined to accept it. Now, your lordship. Since no amicable settlement could come between the government and the petitioner, in spite of the government offering to settle the matter,
Yes.
the petitioner declining the offer given by the government, and therefore the government took a decision. Took a decision on the special inquiry committee report. And basing on the report, the special permit that was given to the petitioner's father way back in 1971 was cancelled with immediate effect. Your lordship will find that cancellation order at page 80.
So meeting failed.
Meeting failed. Meeting failed, decision taken, my lord.
So where is the cancellation?
Page 80, annexure P of the writ petition, my lord. I may be allowed to read, my lord, this order.
Yes, please.
Order dated 24th of September 2018. In pursuance to the letter from the Home Department, Government of Nagaland, via letter number such and such dated 14th of September 2017, regards to the special inquiry report on the special permit issued to late Wanshu Konyak for farmland at Tejit headquarters. The permit number such and such, known 29/3/1971, is hereby cancelled with immediate effect in view of the expansion and development of Digit administrative headquarters, requiring all vacant land for public office establishment.
Okay.
Now, my lord. After this order was issued, cancelling the special permit, the petitioner again represented to the government. And, your lordship, he has stated that he is willing for settlement and closure of the matter.
Now come back.
Yes, your lordship. Now, again, he has put certain conditions there, your lordship. Now, your lordship, I'm jumping, but your lordship, I would like to go to the affidavit in opposition filed by the state in WPC 58, in WPC 58 of 2017.
Respondent number one.
Yes, my lord.
Yes.
This is done, this is submitted by the Chief Secretary of the State of Nagaland, my lord.
Hmm.
Now, your lordship, here,
Page,
page, your lordship, page 5. Page 5 of my affidavit in opposition, your lordship. Page 5, para will be, your lordship, 2I. 2, para 2,
just a minute.
close I.
Para,
Para 2, close I. At page 5, my lord.
yes.
Now here, your lordship, we have again make a statement that petitioner thereafter approached the government for resettlement. But with certain conditions again, your lordship. Here we have mentioned, your lordship, if I may be allowed to read, your lordship, again from
Please.
1, 2, 7 line from the bottom again, my lord,
From the bottom.
from the bottom. It starts with a report.
Yes. Please.
May I read, my lord?
Yes.
A report was thereafter submitted that Sri L. Nogman Konyak is willing for settlement and closure of the matter. If besides allotting the land under physical occupations to him, the vacant field located behind his residence, which is a part of the land falling within under the special permit, is also allotted to him. On this stretch of land, permit for plots was issued by the office of the ADC Digit in 2012 to various individuals. So he came back, your lordship, and he came back with the conditions. Then, your lordship, the government, taking his representation into consideration, has again directed the deputy commissioner to go for a survey. Now, your lordship, a survey was conducted and the survey report was submitted.
Survey of what?
Survey of the entire area again, your lordship. Because now the petitioner is stating that for settlement. For settlement, your lordship, the place where he is presently occupying, that means the place where his residence is constructed, as well as the vacant field located behind his residence be given to him. So now the survey was again at his instance and at the submission of his representation, a survey was conducted.
So this was done on the basis of the representation submitted to the
Correct.
petitioner.
Correct,
And
correct.
except Q,
No,
which,
no, your lordship, not annexure Q.
which annexure?
Annexure 8, page 24 of the same affidavit. Annexure 8.
Okay, the representation submitted by the petitioner is not in the writ petition.
No, it's not in the writ petition,
Okay,
but you have stated it. And even in the survey report,
okay, so here in the affidavit,
Yes.
we find,
annexure 8, page 24. Annexure 8, page 24, my lord.
yes,
Now, your lordship, before I go into this particular,
no, this is special permit for farmland. This is something different. So this is in affidavit 58.
yes, in affidavit 58,
Okay, affidavit in 58.
yes.
Annexure
Annexure 8,
Page
page 24.
is a special permit for farmland. It is addressed to Deputy Commissioner.
No, your lordship, if you see the body,
Written by additional
correct, correct. Your lordship, if you read the body of the letter,
Okay,
it is clear. It is clear.
Okay.
To the Deputy Commissioner, now, Your Lordship, this report was submitted by the Additional Deputy Commissioner Tijit.
Yes.
Additional Deputy Commissioner Tijit,
Hmm.
and it is submitted to the Deputy Commissioner Mon. It states, sir.
Yes.
Sir, reference is WPC 58 of 2017, my lord. Reference is the same repetition only.
Yes.
Sir, in reference to the Home Department letter number such and such dated 27th of January 2020, and as directed by the authority, survey was conducted on 31st of January 2020 with the assistance of surveyor, Department of Land Record and Survey, MONT, and DBs of Digit. Detailed survey report with respects to the land under the special permit as sought by the Home Department is provided as per the format requested.
Hmm.
1. Total land as per the survey is 157.81 acres.
Yes.
2. Allotted to government department offices by the office of the ADC Digit, 0.9280 acres. 3. Allotted to private individuals, organizations by the office of ADC Digit, 38.0014 acres. 4. Allotted to private individuals, organizations by the office of ADC Digit, and the plots are presently vacant with no construction carried on it, 4.43 acres. It says, the area which are vacant and where draft permit has been issued by the office of the ADC Digit. Number 5. Sold, given to private individuals, organization by Sri L. Nogman Konyat, and permits obtained for the same from the office of the ADC Digit, 76.912 acres. 6. Sold, given to private individuals, organization by Sri L. Nogman Konyak, and no permit obtained from the ADC Digit, 17.548 acres. And it says, Sri L. Nogman Wanshu residence and his fishery pond, measuring 0.667 acres, is also within this area. Number 7. Sold, given to private individuals by Sri L. Nogman Konyak, and permit taken, but the plots are presently vacant with no construction carried out on it, nil. Next page, my lord. 8. Sold, given to private individuals by Sri L. Nogman Konyak, and not permit taken, and the plots are presently vacant and no construction carried on it. 2295 acres. 9. Sold, not occupied by private individuals, organizations, and not sold, given by Sri L. Nogman Konyak, and permit also not given by ADC Digit, 0.5171 acres.
So this is illegal occupant.
Yes, these are illegal occupant.
Hmm.
Lordship 10. Vacant plots and not sold, given by Nogman Konyak, and no permit given by office of the ADC Digit, 7.674 acres. And circular roads and drainage is 16 acres. Your Lordship, the next.
So the remaining land is only 7.674.
Yes.
Hmm.
Now, Your Lordship, the next para,
Yes.
it says, the total area claimed by Sri L. Nogman Warshu to arrive at out of court settlement is 5.1 acres, out of which 4.43 acres is presently vacant with no construction, and 12 permit has been issued by the office of the ADC Digit, and the remaining 0.67 acres is his residence and fishery pond. Now, Your Lordship, with this para, I would like to once again remind this honorable court that this survey was done after the petitioner submitted a representation to the government for resettlement with a condition, which we have mentioned it in our para 2 clause I of our affidavit in opposition.
So this is only reports, the status.
No, this is the survey.
No, the survey report only.
Yes, this is the survey report.
And then by this last paragraph, what do you want to show?
What I want to show is, your lordship,
Hmm.
the huge portion of the land that was allotted to the private individuals by the office of the ADC.
Huge plot of land.
Yes, allotted or permit granted by the office of the ADC involved those land which was sold by the petitioner to private individuals, which can be seen clearly from para 5. Which says, your lordship,
So what about this land
yes,
sold given by the private individual, given to private individual by the petitioner, say 76.912 and then the 17.548.
yes, lordship, see,
These whether these lands are still under the occupation of these people.
yes, because permit has been granted
Uh,
by the office of the ADC after the petitioner sold it.
These are T estates. T estates.
T estate.
The petitioner has sold portions to a few individuals, which is mentioned over here.
Okay.
So, since it is huge areas of T estate, so it is not that he has turned all this to so many individuals, but around 12 individuals is referred to in this finding. So these are T estates which were sold in chunk to these few individuals.
Okay.
So, but so
So
far.
this, the government is not
to-
disturbing so far.
Yes.
The government is not disturbing to these 12%.
Not disturbing.
Your lordship, the petitioner has sold of this much plot of land, the 76.912 acres.
Yes.
And because the petitioner has sold it and the individuals who have purchased it came before the office of the ADC Digit to issue permit. That's why the permit has been issued. That's why it's clearly mentioned.
Okay.
It's clearly mentioned. Sold given to private individuals organization by Sri L. Norman Conrad and permit obtained for the sale from the office of the ADC
Okay,
Digit.
they obtain,
Yes,
already obtained.
yes.
Few of them who were allotted the land, they also obtained, yes.
Okay,
They
okay.
also obtained, but
So
it has not been done.
After being
All
gifted
the-
by you, then they obtain.
Not gifted, your lordship, sold.
In some
So-
cases, gifted, in some
Okay.
cases,
And-
sold. It
Okay,
is a finding of the government, and it is not necessary to go into all this.
right.
all
Well,
this
just
detail.
for
Yes,
information.
but
No, your lordship, why not?
it is my.
Why not, your lordship? Why not? What is wrong in going here, your lordship? And your lordship, now the petition is saying that, okay, this is a T estate.
Ah,
Why if they contested that?
They have also not contested that issue.
okay,
That is not a case.
We have put it before the court. Why should we contest? This is our record.
okay. Please,
Yes.
please.
And so, my lord,
So, yes, this
So-
survey report was submitted to ADC,
yes,
was
And-
submitted to DC. What happened thereafter?
yes, no, your lordship. Yeah. When was this survey conducted?
Now, you did not tell
Yes,
just a minute, after permit was cancelled,
yes. The petitioner submitted a representation.
where is that representation? Where?
Your lordship, we have already mentioned here in our para, in our affidavit in opposition, at para 2I.
Para 5.
Para 2I.
Sorry, sorry, page 5,
Page 5.
para 2I.
Right.
But-
But not only that, not only
But the
that.
copy of the representation is not there.
Not there. So not only that, look at the survey report, and then what was the survey conducted is clearly mentioned.
So petitioner also not annex this copy of representation.
No, they have not even disputed this. They are not disputing this at all. We have filed this affidavit, your lordship, way back in 2nd of March 2020.
Okay, okay. So
And they have not disputed this.
then on the direction of the governor, order for survey of,
Yes.
so
No, not direct, but on the basis of the representation submitted by the petitioner to us, the resettlement. This survey was conducted to see whether the demands made by the petitioner can be met with or not, your lordship.
so no, petitioner submitted representation.
Yes.
So on what, where do we find directing the conduct survey?
Yes,
Who ordered for the survey?
the home department, government.
Home Department, where do we
Yes.
find that letter?
Your lordship, see, in the survey report itself,
Hmm?
in the survey report itself, it is mentioned
No,
in reference.
No separate copy is there. Okay,
In reference, but it is mentioned in reference,
only reference.
in reference to the home department letter. See, number such and such dated 27th of January 2020, and as directed by the authority. Survey was conducted on 31st of March 2020.
So this 27 January 2020, we don't have the letter. No,
No,
okay,
your lordship, survey was conducted on 31st of January 2020.
yes,
And this is the survey report,
31 or one,
31 January 2020.
where do we find that there?
Your lordship, in this letter dated
29,
yeah, page 24, my lord.
yes. It was submitted in the 1st February.
Yes.
So,
The survey was conducted on 31st of January 2020.
okay,
And the finding of the survey is this, which is incorporated in this letter dated
Right.
1st
right.
of February 2020.
Hmm.
Now, why I'm bringing this is because this survey was conducted after the representation was received from the petitioner for settlement
Hmm.
with the condition, which we have mentioned in our para 2I. Not only that, your lordship, if you see the survey, in the survey report, the last para, it ends with, C, your lordship.
Hmm.
The total area claimed by Sri L. Wanshu Konyak to arrive at out of court settlement is 5.1 acres. So he has submitted the representation to us to arrive at out of court settlement, with certain conditions. That is, we have mentioned here in our para. To give the land, which is presently occupied by him, and also the vacant field located behind his residence.
Where?
Here at page 5.
Okay. Hmm. Allow the land under physical occupation
Yes,
and the vacant field.
located behind his residence.
Okay, this is his demand.
Yes,
Right.
this is his demand, and therefore, this survey was conducted.
Hmm.
And it was found that if we concede to this demand,
Hmm.
the total area is coming to 5.1 acres.
Yes,
Page 25,
yes.
5.1 acres. And out of which 4.43 acres is presently vacant. And the house where he is residing, that is also one of his demand. It says has been issued by the office and the remaining 6.67 acres is his residence and fishery pond.
So,
So this particular survey report is very relevant as far as this present repetition is concerned.
uh, 5.1 acre, out of which 4.43
4.3.
acre is presently
Yes,
vacant
yes,
with no construction.
yes. Now this vacant plot of land he is demanding, as well as the house, his house, he is demanding these two.
And then 12 permit has been issued by the office of the ADC and the remaining 12 permit is not connected with this 5.1 acre.
No, it's there.
Huh?
It's there. And with no construction and 12 permit is been issued by the office of the ADC digit and remaining 0.67 acres is his residence and fishery pond.
Oh, no, this 12 permit is issued out of which land?
Out of the 5.1 acres,
Okay, within this 5.
within this 5.1 acres,
Okay.
4.43 is remain.
He is claiming this 12 permit, the area under 12 permits also.
No, he is claiming 5.1 acres
Oh,
as well as 0.67 acres.
Okay,
That is his residence. Now, out of that 5.1 acres, 4.43 is presently vacant. Because these are the areas that he has been demanding.
out of which 4.43 acres is presently vacant with no construction.
Yes. And his residence holds 0.67
So
acres.
this sentence 12 permit has been issued by the office of this comes in between. What is this? And 12 permit has been issued by
Yes.
what?
This comes within 5.1 acres.
This 12.
Yes,
also.
yes. Small portions of land. But your lordship, even this 12th permit also has been subsequently cancelled by the
Oh, this
government.
is also
Yeah,
cancelled.
this also has been cancelled.
Okay. So nobody is nobody is occupying presently.
No, your lordship.
Okay, okay. So then this is the report.
This is the report.
And then what happened thereafter?
Now, your lordship,
Hmm.
the next is the background of the survey that was conducted. And your lordship, I will straight away go to the present status at page 27.
The
Page,
requisition.
yeah, no, your lordship, on the same affidavit of opposition.
Okay, page 27.
Yeah, page 27. The present status.
Yes.
It says, if I may be allowed to read.
So this is in the back.
Yeah, page 27, the
this
last
back-
page.
This background is also part of what?
Yeah, it's part of the survey report.
So this present survey report.
Yes, correct, my lord. Correct.
Okay. Continuation of page 26.
Yes,
Okay.
yes. And at the end, it ends with present status.
Just a minute. The next page. Background.
Yes.
Hmm.
Page 27, my lord.
Yes.
Yes,
Yes.
present status. On 27th of January 2020, the Home Department directed the office of the ADC TG to submit details of the land via letter number such and such. Accordingly, survey was conducted and the following are the detail. 1. Total land as per the survey, 157.81 acres. Area allotted by the office of the ADC TG, 38.0014 acres. And 3, area of land sold or gifted by Sri L. Nogman, 76.912 acres. This is the present status, Your Lordship. Now, Your Lordship. Consequent to this survey report, the letter dated 25 of January 2020, which is at page 81 of the writ petition 88 of 2022. Page 81, annexure Q.
Page 81,
81,
annexure Q.
annexure Q.
Okay.
Now, consequent to this survey report, this letter dated 25 January 2020 was issued by the Principal Secretary Home, which is impugned in the present writ petition. Lordship, if I may be allowed to read.
Yes,
Letter dated 25 January 2020. Subject, regarding special permit for farmland at Tijit, 29/3/1971 to late Sri L. Wanshu Konyak. Sir,
yes, madam.
yes,
This is consequent upon the survey.
survey report
Okay, so this is passed by,
by the Principal Secretary Home.
okay, yes. Yes,
Lordship,
yes, please.
sir, please refer to the subject cited above and the letter dated 1st of February 2020. Your Lordship, we are referring to this, 1st of February 2020. From the ADC Tijit addressed to you with regards to the status of the entire land under the special permit as is existed on date. And another letter dated 8 January 2020 from the ADC Tijit addressed to you, mentioning the meeting with Sri L. Nogman Wanshu for settlement of the entire dispute concerning the aforesaid land. Number two, the detailed report of ADC Tijit of the land under the special permit shows that, Your Worship, this is the reproduction, this para is a reproduction of the survey report that is mentioned here in the letter dated 1st of February 2020. The detailed report of the ADC Tijit of the land and the special report shows that out of 157.81 acres of land, initially Sri L. Movement Konyak has over the decades sold given 94.0195. Now, Your Worship, how did 94.095 came? Your Worship, this is the total area of the land, Your Worship. 76.912 acres as per the report, Your Lordship, has been sold has been sold to private individuals and organizations and by the petitioner, and the permit is obtained from the ABC office. Digit. Another 17.548 acres of land was sold or given to the private individuals organization by Sri Northman Konyak with no permit obtained from the ABC Tijit. So the total area, Your Lordship, it is there in the report. Both these areas are mentioned in the report. If Your Lordship may kindly refer the report, 1st of January, 1st of February 2020, annexure 24. Column 5 and 6. 5 is sold, given to private individuals, organization by Sri L. Nogman Konyak and permits obtained from the same from the office of the ADC Tijit. Area is 76.912 acres. 6. Of sold given to private individuals, organization by Sri L. Nogman Konyak and no permit obtained from the ADC office Tijit. Area is 17.548 acres. Now, if these two areas are clubbed together, it comes to 94.0195 acres.
Yes.
That is why in the letter it is mentioned 94.0195 acres. Lordship, of land to various individuals, organizations, which is about 60% of the total land. The area of the land which is allotted to private individuals, organization by the ADC office digit is 42.4314 acres. Your Lordship, shall I explain as to how this 43 point?
The area of the land which is allotted to private individual by the office of the ADCTG is 46.
Yes. Yes, Your Lordship. This 42.314 acres is a total of 38.
Yes.
That is 3, column 3.
And
Yes, 33
and 4.
and
4.
yes, yes, my lord. 3 and 4. 3 and 4. Lordship,
Yes.
may I continue, my lord?
Yes, please.
The land utilized for government department offices and for roads and other public utilities like drains is just 16.928 acres. The report also mentioned that after resurvey, the land under actual possession of Sri L. Nogman Wanshu Konyak, his residence and fishery pond is 0.67 acres and not 5.1 acres as reported earlier. Now, this was reported in the special committee report, Your Lordship. The report states that the vacant land behind his house of Sri L. Nogman Wanshu Konyak, which was allotted to 12 private individuals by ADC TG in 2012, and which is being asked now by Sri L. Nogman Wanshu Konyak for settlement, covers an area of 4.43 acres. Now, this is what is mentioned in the report itself. So now Your Lordship, his demand is the remaining vacant land of covering an area of 4.43 acres, as well as the area 0.67 acres where his residence is located, be given to him. And how this area came is because a survey was conducted on the basis of his representation.
So 4.43,
Yes,
0.67
yes,
is 5.1.
yes.
Okay.
May I continue with the letter, my
Yes,
lord?
please. Yes, please.
3. It is thus clear that Sri L. Nogman Wanshu Konyak has over the years already disposed of a substantial portion of the land under the special permit, which was given to his late father for cultivation purpose only by selling, giving to many private individuals, organizations without any intimations or consent of the government. Hence, it will not be proper to consider allotting any more land to Sri L. Nogman Wanshu Konyak the ADCTG may accordingly be asked to convey the same to Sri L. Nokman Konyak. Number 4, as recommended in the special inquiry report headed by the committee, headed by the ADCTG, you may make allotment to Sri L. Nokman Konyak only for the land measuring 0.67 acres, which is under his actual possession. Further, as also recommended in recognitions of the service rendered by his father, Sri L. Nokman Konyak, ADCTG may be asked to take concrete steps in the directions of getting a school or public hold in the locality named after Sri L. Monshu Konyak. Number 5, further, in public interest and taken into account the present circumstances as it exists in town area, all the vacant plots, tracts of land falling under the special permit need to be kept for the use by any government officers or for taking up any development activities that may come up in future. Hence, you may take immediate steps for cancelling the allotment covering an area of 4.43 acres to 12 to private individuals made by ADCTG in the year 2012, which is a consolidated tracts of land at one place, and mentioned as serial number 4 in the report of the ADCTG, first dated 1st of February 2020, and take under the custody of the government. The vacant plot 6. The vacant plots not sold, given to the private individuals by Sri L. Wanshu Konyak or allotted through any permit by ADCTG, as well as those plots sold, given to private individuals by Sri L. Nokman Wanshu Konyak, but vacant, mentioned as serial number 10 and 8 in the report of ADCTG dated 1st of February 2020, which measures 7.67 acres plus 0.22295 acres, comes to 7.9035 acres, may also be taken over by the government. In all other cases, proper allotment orders in a manner as considered appropriate by you may be made so that there is absolute clarity that these tracts of land belong to the government. Number 7, as regards the land already allotted to private individuals by Sri L. Nokman Wanshu, and which are not vacant, with some construction done or some development of the land done in some manner, and for which permit has not been issued or given by the ADCTG, as mentioned in serial number 6 of the detailed report from ADCTG dated 1st of February 2020, you may prepare a proposal and submit to this office for regularization such allotment by giving permit issued by ADCTG. Action on similar lines may also be taken for an area of land 0.5171 acres, which is not vacant and over the years have got occupied by private individuals, organizations without being allotted by ADCTG or being sold, given by Sri L. Nokman Wanshu Konyak, as mentioned as serial number 9 of the report, dated 1st of February 2020. Number 8, you may take immediate steps for taking action.
8 is not there.
Lordship.
Page 83 is something else.
Page 83, your lordship, page 83 is actually the,
Page 83 is something else. Renegotiation.
no, your lordship, page 83 in my copy of my repetition, it is the last para of the letter.
No, maybe somewhat.
Read petition. 88. Yeah, page 83.
So, no, after 82, it comes 83 is something else. Is there? This 83 is annexer R. Oh, this is correct. Just a minute. This is in 84, yes,
No, Lordship, yes.
84.
If my lord has,
This should be 83.
yes,
Yes,
if my lord has got page 83, may I read the
Yes,
para
please.
8?
yes. Para 8?
Para 8, yes. You may take immediate steps for taking actions on all the points as mentioned above, and a report regarding the same may be submitted to this office at the earliest. So, your lordship, this letter
Yes,
This letter was issued by the Principal Secretary, Home Department, taken into consideration the survey report submitted by the ADC Digit to the Deputy Commissioner Mond, which was subsequently placed before the government.
yes.
Now, your lordship, petitioner, these are the facts that I have highlighted, my lord.
Yes,
Now, petitioner is claiming to be a landowner. All along, your lordship, all along, even in the prayer that he made as well as in his statement, he is claiming to be a landowner, and he says that the allotment given by the government for establishing its own office itself is encroaching over his land. To claim or to even show that he is the owner of the land, the petitioner has to first show before this honorable court as to how he is the owner of the land. Number one, is the land that he is claiming to be the owner inherited by him? Is it his inheritance property? Has it owned by way of purchasing the land?
that he's not claiming also.
He is claiming, your lordship.
Not in.
He is claiming, therefore he is seeking compensation.
Lordship, I'll come to that after.
He is seeking compensation. Look at the prayer, lordship, made in the report. He is seeking compensation from the government. Now, your lordship, on the basis of a special permit granted to his father, the petitioner is now claiming to be the owner of the land. Now, as stated by me, your lordship, and as we have gone through the permit itself, what does it say? The permit was granted or issued to the petitioner's father for a particular purpose. And what is that purpose, your lordship? Is for cultivation. Beyond that, when has the government regularized this special permit in the form of an allotment order or mutated in the name of the petitioner's father or even in the name of the petitioners itself? Where is such allotment order or where is such permit that says that shows that this special permit has been regularized in the form of an allotment to either to his father or to the petitioner itself? He is here before this court on the strength of the special permit alone, your lordship, nothing more.
Yes.
He is claiming that he is the landowner on the basis of the special permit that was granted to his father. Now, your lordship, let us go back a little further than that, your lordship. How did the petitioner father started cultivating this land? Or whose land it originally belongs to, your lordship? It is very clear from the special inquiry report as well as from the letters submitted by the Jaboka village that the land originally belongs to the Jaboka villagers. Is the petitioners from Jaboka village? No. Is the petitioner refuting the fact that Jabaka village has donated this land to the government? No. Is the petitioner refuting the fact that the land that was donated by the Jabaka villagers to the government, a portion of that land is given to the petitioner's father for cultivation purpose? Is he refuting that? No. Which clearly means that, Your Lordship, the land originally belongs to the Jabaka village, donated to the government. What happened, Your Lordship, after the land was donated to the government? The government took possession of the land. And since the government took possession of the land in lieu of the land being donated to it, the state government becomes the owner of the land. From the issuance of the special permit itself, Your Lordship, if I am not an owner to certain things, I will not be able to issue permit to do something on the land itself. And therefore, Your Lordship, I being the owner of the land, I allow somebody to do a certain things or a specified things over my plot of land by issuing a permit. Now that permit, what happened in this case is transformed into something else. Now, Your Lordship, a person cultivating my land, because I permitted him to cultivate my land, can come back and say, like, now because I have cultivated the land, and that because the permit was not cancelled, now the land belongs to me. Can anybody make such a claim, Your Lordship? In order to claim ownership over the land, Your Lordship, I being the owner, I should either sell the land to him or I should allot the land to him. Where is such sale deed or where is such allotment order that shows that I have given the land to him. Okay. Your Lordship, that's one. Second, Your Lordship, who was the permit granted to? The permit was granted to his father. Can a permit be inherited, my lord? It is exactly like, Your Lordship, a permit was granted to somebody.
Was it a conditional permit?
No,
Ah.
but it was for a purpose. It was for a purpose, for cultivation. It was for a purpose.
Yes.
Where does the permit says that the land now henceforth is allotted to the petitioner's father? What does it say? It says the land is given to the petitioner's father for cultivation. So it's conditional, yes.
Area also not prescribed.
No, Your Lordship, but then if I issue a permit and the person to whom the permit is being issued or received, if that person died, can the permit be extended to his generation? If that is so, Your Lordship, the petitioner may prove it. Because this permit was never granted to the petitioners, Your Lordship. It was granted to his father who subsequently died. And the son to whom the permit was never granted is now selling off the plot of land at an exorbitant rate. So it comes back to one question, Your Lordship. Who is the real owner as of today, Your Lordship? It is still the government. As I've stated, Your Lordship, the special permit has never been regularized in the form of an allotment order. It is still a special permit. And that too granted to his father, not to the petitioner.
Okay.
So what wrong is it, Your Lordship, if we cancel the permit? Because the permit that was granted to his father is now being abused by the petitioner without taking the consent of the government, who is the real owner, has been selling off. So that answers the first prayer. That answers the first prayer of the petitioner in this present writ petition. Your Lordship, I am the owner. I am the owner of the land. The government is the state government is the owner of the land. The permit that was granted to his father is being abused by his son. The permit was never granted in the name of the petitioners. He is not the owner of the land. However, by abusing the special permit that was granted to his father, he has been selling off the land, Your Lordship. And therefore, the permit is now cancelled. What wrong has the state government committed? It is my land, Your Lordship. And I was the one who issued the permit to the petitioner's father. What wrong have I committed if I have cancelled the permit? There is no wrong at all, Your Lordship. Now, as far as the impugned letter is concerned, impugned letter dated 25 January 2020, page 81.
Is
81.
yes.
Your Lordship, on bare readings of the writ petition,
So these and the cancellation order are impugned, I think,
yes,
too.
yes.
Yes.
Now, Your Lordship,
Hmm.
this letter is impugned on the ground that this letter should have been issued by the Chief Secretary,
This was issued by,
by the Principal Secretary.
okay.
And what is the petitioner claiming that, Your Lordship? The petitioner is claiming that on the basis of the judgment and order passed by this honorable court in the PPC 204K of 2012. Allow me, Your Lordship, to take back to the judgment and order dated, Your Lordship, 5/8/2014 at page 50 of the writ petition.
Yes.
Relevant portion, Your Lordship,
Yes.
page 53.
Yes.
53.
Yes. Yes. Just read.
It says, the facts as to the issuance of direction by the Chief Secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Mon to hold special inquiry as was directed by the Chief Secretary by order dated 18/7/1996. From the date of receipt of a certified copy of this order without fail, and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass final orders within 2 months from the date of receipt of an inquiry report from the Deputy Commissioner Mon. Now, according to the petitioner, this order has not been complied. is this impugned letter, Your Lordship, issued on the basis of this special inquiry report as directed by this honorable court? Or is it on the basis of the survey conducted on the representation received by the government from the petitioner? Your Lordship, I'd like to take my Lordship to para 24, at page 24 of the read. How are they impugning this letter?
Please,
Page 24,
yes.
para 24. May I read, ma'am?
Yes.
That when the judgment and order dated 5/8/2014 in WPC 204K of 2012 specifically directs upon receipt of the special inquiry report of the Deputy Commissioner Mon, the Chief Secretary shall pass final necessary orders within 2 months. The Chief Secretary, Your Lordship, see, the Chief Secretary could not have delegated the duty imposed upon him by the Honorable Court to the Principal Secretary Home, Nagaland, and the Deputy Commissioner Mon, as has been done in instant case. The Chief Secretary and no other can pass a final order in the light of the Honorable Court order. The instant case is a classic case of abdications of power. The imperial order dated 24/9/2018 issued by the Deputy Commissioner Mon and the imperial letter 25/1/2020 issued by the Principal Home Secretary Home being issued by unauthorized officials are void ab initio and liable to be quashed and set aside. What is the order passed by this Honorable Court, Your Lordship? Is this letter, Your Lordship, has got anything to do with the inquiry committee report, Your Lordship? This letter was issued on the basis of the survey that was conducted. Not only that, Your Lordship, the petitioner, the letter dated 26 January 2020 is the consequent letter.
What is that letter? Where is that letter?
81, page 81, Your Lordship.
Okay.
Is the impugned letter. Was the impugned letter dated 25 January 2020 is the consequent letter of the survey report that is 1st of February 2020. This is the consequent order. Is the petitioner impugning this survey report? No. He is impugning the consequential order, not the main order. Now the question is, Your Lordship, besides Adjournment made that this particular impugned letter, 25 January 2020, is not passed by the appropriate authority. Besides that, is he challenging any of the anything that is mentioned in this letter? No. It's just besides that this has been issued, not in compliance with the order passed by this honorable court in its order in the WPC 204K of 2012. Besides that, Your Lordship, has he made any amendments here? No. Has he challenged this particular survey? No. And can he challenge this impugned order, Your Lordship? No. Because this was issued basing on the survey report, which the petitioner has not challenged, meaning thereby he has admitted this. Whatever is being stated here in the survey report, this was with him, Your Lordship. This report was with him from 2nd of March 2020, when we filed this affidavit in opposition. The content of this particular survey report was with him. Even in the present writ petition, the WPC 88 of 2022, has he challenged this? No.
Does the survey report say anything against the petitioner?
Yes.
Okay.
That he was the one who has been selling a huge portion of the land. It's here. And therefore, this letter, impugned letter, is reiterating what is mentioned in the survey report.
Survey report probably is about the status of the lane, not making any adverse remark against the petitioner, probably.
No, Your
Has
Lordship.
has they met?
Your Lordship.
Ah.
No, Your Lordship.
Hmm.
Because of the survey report,
Hmm.
this impugned letter was issued.
That is right. Hmm.
Now,
That is right.
because of the survey report, Your Lordship, because of the survey report,
Hmm.
now, a photo,
Survey is about the factual position of the
Correct.
lane.
correct,
So in the survey, nothing has been said against the petitioner.
it has been said, Your Lordship, that he has been selling huge plot of land.
That is also fact,
That is also fact.
which he also did not deny.
Do not deny, Your Lordship.
So survey is only about the factual position of the lane.
Yes. So what is wrong in this informal letter then?
Probably not agreed by the survey report. And an consequential order passed after on the basis of the survey report, drawing consequences. that
Yes.
These are the position, hence, so said then he is agreed by the consequential order.
Okay, Your Lordship. Then in that case, because of the survey report,
Hmm.
a portion of the land
Hmm.
measuring 6.67 acres,
Hmm.
that is this building that is standing today,
Hmm.
is allotted 0.67 acres.
Hmm.
There is that where the building, where his residential building is standing today,
Yes.
has been allotted to him by order dated 25 February 2020. Is he impugning that then? No.
Okay.
Is he impugning that in the repetition? No.
No, allotted, whether he applied for the allotment.
No, because this is what has been decided.
Okay.
This is what has been decided as per the survey report.
Okay, as per the decision, he was allotted.
Yeah, so he's impugning that. No.
There are only two substantive orders. One is issued by the deputy commissioner cancelling the initial permit.
Hmm.
And the other one is the letter whereby the deputy commissioner is directed to.
You,
cancel.
one
So-
thing, you have been allotted this 0.6 so and so lane.
By the letter, by the impugned letter, yes?
No, by an impugned order. By an impugned
By
order
the
dated
impugned order also?
25th February 2020, which we have annexed it.
Okay.
Which we have annexed it in our affidavit of opposition. Has he impugned this then? No.
Your Lordship, the impugned order is very clear, Your Lordship. There are two orders, one issued by the deputy commissioner. Cancelling the allot, and then allotting me the only area where I'm staying. That is one.
So what he's saying is you are not
What he's saying
impugning
is-
that
No.
allotment.
What he's saying is I should challenge, impugn all the inquiry reports. No, inquiry.
No,
reports-
I'm not saying that, Your Lordship.
The inquiry
Since,
reports are merely findings with some recommendations. The recommendation may not be acted upon, may be acted upon. Ultimately,
Okay.
the only, the
Okay.
order which affects my right, I need to impugn that. He is saying that all
Focus.
these so-called findings should be impugned.
so, Your Lordship,
I haven't.
on the finding of this survey report,
Hmm.
a portion of the land that is 7.67 acres,
Hmm.
which is mentioned in the survey report, is allotted to him. by an order dated 25 February 2020, which is available in annexure 9, page 28 of my affidavit in opposition filed in WPC 58K of 2017. Is he implement that then this, Your Lordship? No. Page 29, Your Lordship.
29.
29. Sorry, Your Lordship, page 28. Yes. Yes. Yes.
If the impugned letter is twice and set aside, the foundation goes, the resolving order also goes, Your Lordship.
Okay, just a minute. So this allotment, he did not apply for allotment.
No, but this is what has been from the survey.
This is suo moto.
No, Your Lordship. No, so, Your Lordship,
Ah.
if it is suo moto,
Ah.
and if he is agreed by the suo moto decision,
Ah.
is he challenging that? No.
So he has,
No, but also he is admitted.
definitely he has accepted.
Ah, correct, my lord.
Hmm.
That's what I'm saying.
So while accepting some,
Yes, but yeah, accepting then by acceptance of this order, how can we impugn? How can we impugn this letter dated 25 January 2020?
so just a minute. So this 25th February 2020,
Yes.
order allotting you the 0.67 lane.
Yes.
You are not
I am
impugning it.
No.
impugning this. I am impugning this. Now,
Where?
Your Lordship, in my prayer,
Hmm.
the impugned letter. This is the impugned letter, 25th January 2020. Impugned
No,
letter.
this 25th January is which one you are?
Issued,
Yeah.
issued by the Home Department.
No, this was issued by the additional.
No, but it
ADC.
may have been issued subsequently, but if I am challenging the route,
Huh.
the scheduled
No,
position
where-
of that
where in
state,
the- where in the
foundation
order?
goes,
Where in the order dated 25 January 2020 issued by the
I was
principal?
never served with any copy of that.
No, Your Lordship. It is in my affidavit in opposition.
This is the only copy which was available.
So it was before him,
Just
Your
a
Lordship.
minute, just a minute. Where it's, where in
But
the,
otherwise, Your Lordship,
Hmm.
I am challenging the
yes.
main
Okay.
direction issued by the
Okay,
government.
where it says that in letter 25
Hmm.
January 2020 issued by the principal secretary that this much of land has been allotted to
Yeah,
you.
here, you see,
It's there, Your Lordship.
it will be there.
It's there.
Yes.
It is there. It is based on this, that the
Where?
so-called order was issued. So.
Para 4,
Page 82.
which is
Para
under the schedule presence as also, sir.
Yes, 0.67 acres, which is under its actual possession. Further, as also
You may-
stated in the proclamation.
You may make allotment.
Yes.
Only say, it's not yet allotted.
No, it's not there, Your Lordship.
Where?
It's not there.
Kindly read.
Your Lordship, order dated 25th of February 2020.
Hmm?
Order dated 25th of February 2020.
Yes.
And next, Your Lordship, in my affidavit in opposition in the WPC 58.
Mhm.
Last page.
No, just impugn order.
Last page.
Page 28.
Yes, page
No,
28.
that is allotment. What
Yeah, that is allotment.
No. What he's saying
Yes.
is since he has already challenged the very route,
Yes,
so this not required to be challenged, what he's saying. And I'm asking him where we can find that you have challenged the allotment order.
correct.
So where it says that it is allotted to you.
No, Your Lordship, at the time of filing this petition, this
Hmm.
was the only one available, and I was of the opinion that the earlier order, that is, page 80. Page 80, Your Lordship, I see here. This is an order passed by the Deputy Commissioner cancelling the entire allotment, Your Lordship.
Yes, sir, that is there.
So I was of the opinion that,
No, that is
yes,
in the year 2018.
yeah,
Okay, then
Now, after
subsequently,
this-
just a minute,
yes,
I need to clarify.
yes.
So subsequently, this order, you have also impugned this 25 January 2020.
Yes, 25th
Okay.
January 2020.
So according to you, you
Yes.
say that this, when I ask you that, have you challenged the order
No,
dated 25? Just
because,
a minute.
yes,
Order dated 25 February 2020 issued by ADC, whereby you have been allotted a plot of land around occupied by you, that is
Yes.
around 0.67. So this, what Learning Council for the respondent, state respondent says that this you have not impugned.
Yes.
So
Because it was not available with me, I had no knowledge about that, but I had no.
now
knowledge-
subsequently you were provided
I have-
subsequently.
No, I have not, only after that, they filed the.
Hmm?
Instant reply,
Hmm.
I have come to.
No, no, your lordship.
About
That is a misleading statement, your lordship. We have filed these particular documents on
Let it-
second of March 2020.
Just a minute,
Your lordship, whatever it is.
Hmm.
Here is the, at paragraph 8, you may take immediate steps for taking action on all the points as mentioned above. And a report regarding the same may be submitted to this office at the earliest. A specific direction is being given to the deputy commissioner
Hmm.
to take action
No.
on all this.
No,
Now,
just a minute, just
if
a
I
minute.
challenge this,
Hmm.
if I impugn this, this is the very root. If all these are illegal, it has to go away, then the subsequent order which is passed on the basis of this, because this order, so-called order which I am supposed to have not challenged, this order is passed on the basis of this letter, your lordship. It is, your lordship will see that. With reference to Home Department GAP 1 letter number so and so, letter 25th February 2020. It is issued with reference to this. So if the foundation goes away, all those other subsequent orders which may have been passed based on the foundation also.
So according to you, this order dated 25 February 2020 issued by additional deputy commissioner, this allotment order, according
Yes.
to you, not required to be
Not required to
challenged.
be challenged,
Okay,
Your Lord.
okay, clear.
No, it's not required.
Yes. Okay, please take it.
So in other words, your lordship,
Hmm.
the petitioner has filed this writ petition on assumption that his writ petition will be allowed. Because he's now saying that if this is quashed, then this order need not be challenged. So there is an assumption that his writ petition will be allowed. No, on what basis? That's why I say, on what basis is he challenging this particular letter? Only on the basis that it was not passed by the Honorable Chief Secretary. In compliance with the direction passed by this Honorable Court in WPC 204K of 2012. Besides that, he is not saying that all these things that is being mentioned in this letter are incorrect or wrong. He's not saying that. Therefore, I say, your lordship,
Yes, so because your contention, you challenge this order, not specifically mentioning that this is incorrect.
No, I have specifically
You have mentioned.
mentioned that this is not in accordance because, your lordship.
No, you say that this is not issued by the chief secretary. It should have been issued by the chief
That
secretary.
is one ground.
Had it been issued by the chief secretary, then
No, that is one ground, your lordship. It is for the chief secretary to decide, one
Ah.
ground.
uh,
The other one is that it is not in accordance with the, because it has to be measured, this petition is to be considered within the parameters of the chief secretary's letter and this court's judgment in the 204. It has to be decided on the basis of that, your lordship, because these two are the foundation. Your lordship, if your lordship will allow me to take your lordship to the judgment of this honorable court. What was the direction of this honorable court? What was the
that
finding
we
of
have
this
seen.
honorable
It was
court?
directed to chief secretary. Yes.
Not only that, because the order has to be founded on a context. Without a context, this order cannot be passed. That here, what was the context based on which this honorable court directed the deputy commissioner to take up the inquiry and submit it to the chief secretary. What was the context on which the chief secretary wrote that letter to the deputy commissioner? That is important, not the sequence, the last paragraph. You conduct inquiry accordingly, submit, but the body contains the context. That has not been read by the learned government advocate. What was the context? The chief secretary is saying that this plot was allotted to the father because of his service to the state in times of need. Because of that, this government allotted it to the father. Now it is found, the complaint is that the state has been allotting land to all these individuals. which is not proper. That is the chief secretary's statement. The district administration must honor the decisions taken by earlier administrations. Therefore, proper inquiry be conducted. That means the extent of the encroachments made or allotments made by the state government, all those details may be found out and then submitted for appropriate direction by the chief secretary. That was the letter. It was not acted upon. This honorable court also, the government also not contested that. The honorable court also found that yes, if this is the case, the chief secretary's direction is to determine the extent of the encroachment. If these kind of encroachments and then allotments are being done, it is illegal. That is the findings of this honorable court in the writ petition, that which he has conveniently left out. Your Lordship. Paragraph 4, 3 onwards, your Lordship will see.
Allow me to explain that part, Your Lordship. I did not conveniently left out. I did not conveniently left out. Your Lordship,
Allow-
Just 1 minute.
Yes, allow me to take you, your Lordship, to page, I will take you, because this is the parameter within which this case has to be decided. It cannot go into all these rabbit holes where the state responded, where the state council is taking this honorable court. What is the letter of the chief secretary? That is more important, Your Lordship. Your Lordship will see here.
That we have seen now.
Yes, I'll take your Lordship to the entire finding of the chief secretary. This is very important. This is the basis on which ultimate decisions by the chief secretary is to be made. He cannot deviate from this. They have deviated from this by going into all those unnecessary areas. Your Lordship, this is very important. Your Lordship, page 42, Your Lordship. It is all unnecessary arguments, actually, Your Lordship.
Yes.
Your Lordship, page 42 of my petition. This is the foundation, this is the parameter laid down by the chief secretary. A representation has been submitted to me by L. Nokman Wangshu, son of late Lokten Wangshu, alleging that illegal encroachment has taken place in the land given to his father, which he has inherited. This special permit for farmland at Tizit was given to late Lokten Wangshu, the then RCM, and the area given to him was properly alienated. In course of time, encroachments had taken place by police department, industry department, and also by private individuals through permits given by administration at different times. The land given to late Lokten Wangshu, the then RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in times of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government department. See, it's very clear. Without the consent of the petitioner or his father, no land could have been allotted. That is what the chief secretary is saying. It appears that no respect was shown to the permit holder who was given the farmland by administration for recognition of his services given to the government and the people. Even the arms of disease area had consented to this, see, as the land falls within their jurisdiction. The administration should always honor the commitment given by previous administration to keep its image in the eye of the people. Instead of protecting the privilege given to certain distinguished persons, if the administration allows encroachment by individuals of government departments, it does not show any good image before the public. You are hereby asked to conduct special inquiry and submit detailed report comments as early
What is
as
this
possible.
RCM?
RCM is the regional council member. At that point of time, there was this regional councils in the state. So the petitioner's father was the leader among the RCMs, Your Lordship. So because of his
Yes.
services, this was given, Your Lordship.
Yes.
So it's very clear, the chief secretary
Yes,
is
yes,
making it clear. Now, all these so-called actions, impugned actions, are contrary, completely contrary to this chief secretary's letter, Your Lordship.
Can I make a submission on that? matter?
Just,
Let him submit after I make a submission.
no, no,
Because
just,
it
just
is
a
very
minute. Let us come
important.
to,
Now, there are court
just,
judgment.
no, let us just see
Yes.
who canceled the allotment
By the
permit.
home
Where is the cancel?
There are two consultants. One is by the deputy commissioner, which is
Where is the cancellation order?
the cancellation order is one is by the deputy commissioner, which is at page 80, Your Lordship. This is 28th of September 2018. This is the deputy commissioner,
Okay,
28th of 2018.
okay.
And then the next one is annexure Q, page 81.
Hmm?
The next one is a letter issued by the home secretary, the
Okay,
principal
okay.
secretary home, not the
Okay,
chief secretary.
Okay,
Now, this is for allotting only the portion which the petitioner is currently occupying. And based on which the learned government advocate has produced that subsequent order, which was Your Lordship, there are so many judgments of the honorable apex court and even these honorable courts. The foundation itself goes, the superstructure crumbles. Your Lordship knows very much. I am challenging the foundation itself. So any order which was subsequently passed, if this is found to be unconstitutional, illegal, then any subsequent orders which may have been passed on the basis of this also just goes away. So it is.
the report of the ADC was forwarded by DC to the CS,
No,
Chief Secretary,
it was.
Home Commissioner.
Home Commissioner.
It was addressed to CS or Home Commissioner.
Home Commissioner, it should be, Your Lordship, I'll take Your Lordship to that. Page. Oh, to the additional chief secretary it was, Your Lordship. At
It
that
was
point of-
addressed to,
Yeah.
address.
Yes, additional chief secretary at that.
So
point of
this,
time, On 14 November.
Chief Secretary letter was addressed to,
The deputy
just now you have just read the letter,
Yes, this was direction to the deputy commissioner actually,
Deputy Commissioner.
yes. To the deputy.
But the
commissioner.
Deputy Commissioner submitted the report to the additional.
Yes, yes, subsequently, after that, and then even the judgment is also, if your lordship will go into the judgment of this court, because
Hmm.
this decision, the present instant case has to be decided within the parameters of the judgment of this honorable court, not beyond that, your lordship. The judgment, page 50, your lordship, page 50, 51, in your lordship will see, I'll take your lordship, it's a very short judgment. I'll take your lordship from the, because the state
that is
government
right.
has made no objections in that case. Now they cannot raise all these kind of issues when this judgment was passed. This judgment is the foundation on which subsequent developments were built. Your Lord. And they cannot. At that point of time, they ought to have raised all these issues. They did not raise it, Your Lordship. Paragraph 3, Your Lordship. Page
Yes.
51, paragraph 3, if I may read.
Yes,
I'll leave the introduction, paragraph 2 is about the history, paragraph 3 onwards I'll read. It is a further case of the petitioner that after getting possession of the land, his father died, leaving the present petitioner as minor son and taking opportunity of the same. Some villagers, including one Ping Pong Konyak and Nokzam Konyak, made encroachment in a part of the land situated thus. The petitioner submitted representation before the circle officer complaining of the encroachment. The circle officer held inquiry and thereupon prepared a memorandum on 11/4/1975. This memorandum has been placed at Annexure C to the writ petition, which shows that after thorough inquiry, the jurisdictional circle officer arrived at finding that Dingborn Konyak and Lokdam Konyak have no claim over the land. The circle officer specifically stated that the land within the boundary was given to the petitioner's father in recognition of his service to the nation, and hence nobody else than his heirs can stake claim over the said land. It is very clear, Your Lordship. But unfortunately, thereafter, not only some private persons, but also some departments of the government made intrusions in the land to the prejudice of the writ petitioner. The petitioner therefore submitted representation before the authority, and ultimately it was taken up by the chief secretary for disposal on 18/7/1996. The order passed by the chief secretary on 18/7/1996 has been placed at Annexure F of this writ petition. In this order, the chief secretary has restated the fact as to devolution of the land on petitioner's father and thereafter to the writ petitioner. The devolution of the land to the petitioner's father and also to the petitioner subsequent to the petitioner's father's death. That means the petitioner inherited it. The report is very clear. This court is affirming it. And recognition of such special permit subsequent by the circle officer in the form of memorandum, which is annexure P of the writ petition. Having so discussed the attending facts and circumstances, the chief secretary was of the view that it is necessary for the administration to uphold the gift made by the government in favor of the petitioner's father. The encroachment, if there be any, was found to be deprecable. To ascertain the correctness of otherwise as to allegation of encroachment and quantum of encroachment. That is, what is the extent of the encroachment? That is the only issue left here. Into the land in question, the chief secretary issued specific direction to the deputy commissioner Bond by order dated 18/7/1996 to hold a special inquiry and thereafter to submit detailed report as early as possible. The special report asked for as early as possible has not materialized, even after efflux of 18 years of time till date. 4. I have heard Mr. Subu Chamir, learned counsel for the petitioner, and Mr. K. Watsa, learned senior government advocate, appearing for the state respondents. 5. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, the circle officer prepared a memorandum on 11/4/1975, recognizing the same. If there is any encroachment, definitely, this is prejudicial to his legal and constitutional right. The chief secretary of the state, being aware of the situation, issued direction to the jurisdictional deputy commissioner way back on 18/7/1996 for holding special inquiry. There is no reason as to why the deputy commissioner would not hold a special inquiry as directed by the chief secretary. Although detailed report after such inquiry was supposed to have been submitted before the chief secretary as early as possible, but the proceeding went hibernating without any valid reason, depicting irresponsibility on the part of the district administration. In the process, a proceeding before the chief administrator of the state has been stopped. Failure on the part of an authority in complying with direction of his superior not only betrays inefficiency of the administrative machinery of the state, but has also potential of sending wrong signal to the society as to the rule of law, which is so sacrosanct in a democratic setup of governance. So based on this, although an affidavit in opposition has been filed on behalf of official respondents, the claim of the writ petitioner has not been disputed. So the claim of the writ petitioner has not been disputed in this case, Your Lordship. Now they cannot dispute this here in this particular case, when in the beginning they have not disputed. The fact as to issuance of direction by the chief secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the deputy commissioner Bond to hold special inquiry as was directed by the chief secretary by order dated 18/7/1996 within a period of 3 months from the date of receipt of certified copy of this order without fail, and forward the same to the chief secretary for passing necessary orders. The chief secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of inquiry report from the deputy commissioner. So it is very clear. By this judgment, the court has arrived at the conclusion that it was a gift made by the government to the petitioner's father, and it devolved upon the petitioner's father's demise to the petitioner. It is this. The government reports are also very clear. Now, the state respondents, now the government advocate is trying to project a different picture. Whereas this judgment and the chief secretary's direction and also the earlier two, that means the special permit and the memorandum which was issued by the circle officer in 1975, all point to the fact that the land now belongs to the petitioner. The only thing is that since there has been encroachments, what is the quantum of the encroachment? That is to be determined. The chief secretary has also made it clear. Such encroachments are not permissible. So submit a report. What is the extent of the encroachments? We will issue directions accordingly. That was the position. What happened? With disregarding all these things, they have gone into all these other areas which are not,
Material.
yes, covered by this.
Hmm.
They have even come to the conclusion that is a permit for this farming. So it can be taken away by the government. The land belongs to me. All this. Whereas the judgment and the chief secretary's letter earlier clearly says it is no longer government land. So now, this honorable court has to decide the validity of the imbued orders which I am challenging on the basis of the judgment of this honorable court in the WPC 204K of 2012. which
So
is
now,
not-
now you see on the basis of the direction,
Yes,
acting on the, of course, the letter or the
Yes.
direction of the chief justice, chief secretary.
yes,
The deputy commissioner through ADC, of course,
yes,
has prepared a, means
yes. report.
conducted and then a report submitted.
yes.
And on the basis of the report, only this chief justice again acted.
Yeah, not the chief secretary, but the commissioner, but they cannot cancel because the parameter is very small. What is
Hmm.
the quantum of the encroachment?
Hmm.
It cannot be encroached upon.
Hmm.
This honorable court in the judgment itself has made it very clear. If there is such encroachments,
Hmm.
then it is violating his legal and constitutional rights. So it needs to be determined and appropriate action taken against such encroachment. This is the position. Even the chief secretary's letter is also like that only. So based on that, they
On the
cannot,
basis of the report,
yes,
where your conduct has been revealed, then the subsequently this your land allotment,
Yes.
this was cancelled.
it cannot be cancelled now.
It cannot be.
It cannot be.
It
As
cannot
per the
be.
judgment of the, as per the judgment
Hmm.
of this honorable court and the chief secretary's letter.
Hmm.
It cannot be. If your lordship will carefully go through
Hmm.
the judgment of this honorable court
Hmm.
and the chief secretary's letter, it makes it very clear. The question of cancelling does not arise. The only question is, how far has the endorsement been done? And what will be the remedy for such encroachments? That is the parameter which has been laid down, based on which direction was given. Now, all that the chief secretary is to determine is, all right, this far is the encroachment. This far is these are the portions which have been allotted by the government. Because petitioner being the owner, he can do whatever he wants. That is not a question here. It is not a question. His right over the land is recognized by the judgment of this court as well as the chief secretary's letter. So the petitioner having allotted land to others or sold, the question does not arise. It is his right to do it. The only issue is, who are the illegal encroachers? How many allotments have been made by the state without getting permission from the petitioner in the meantime? That action of the allotment, and then based on that, the chief secretary is to pass appropriate order, whether to,
Okay. Hmm.
but the
So,
question of cancelling does not
so,
arise. Lordship.
Hmm. Yes, you have any power or any decision of the
Your
Supreme
Lordship,
Court
only
in
of
this
the
regard?
decision of this honorable court, because the honorable court, this single bench, this honorable court has passed specific order here. And then now, secondly, even if the state wants to take away my property, Your Lordship, Article 30 300A of the Constitution. Now it is a constitutional right. Right to property can be taken away only by authority of law. Authority of law means there should be a law based on which it is taken.
You have also to submit. Okay, then we'll
Yes.
resume it too.
Yes.
Thank you so much. Your Lordship, I beg to mention item number 25. Let the matter be passed over for the day.
You're for?
For the petitioner.
Exponents are also present?
Yes, Lordship.
Yes, Lord.
Okay. Yeah, any?
No.
Not person. Miss
It's Inasina.
Inman Senla, not a council for a petitioner. Pass over
For the day, tomorrow, so tomorrow.
press 4. Pass over the matter for a day. So when it is to be listed then?
Tomorrow,
Tomorrow.
Lordship, maybe kind.
Tomorrow?
Yes,
Yes,
Lordship.
Okay. Mr.
It's Boko.
Sorry. You're for state respondent,
correct.
okay. Land council for the state respondent. And Miss
Get secret for respondent 5.
Finora for respondent number 5 are also present. Yes, great. Okay, let this matter be passed, over for the day. Yes. This is tomorrow,
His lordship.
okay. Pass over for the day only. Okay, okay.
Lordship.
Matter stands passable, for a day. Yes,
So your lordship, the judgment dated 5/8/2014. The judgment has become final. So far as the ownership, who is the owner of the land in question is concerned. This was passed on the basis of affidavit and also report of the state respondent. Affidavit filed by the state respondents was also taken into consideration. The Chief Court has come to the conclusion that the petitioner and his father are the legitimate owners.
where?
204, page 5/8/2014, WPC 204K of 2012.
Page,
Your lordship, page 50, his judgment. So far as the finding of this is concerned, the main finding, petitioner and his father are,
where is the finding?
your lordship, from paragraph 3 onwards, if I may read, I'll bring specific emphasis on it.
No, that we have read,
Yes,
you have read, already read.
now I say,
So,
5, administration to uphold, all these are here. Now, the only question is to determine the extent of what is the quantum of enforcement.
no, where the declaration?
Your
that-
lordship, see,
Hmm,
page 52, your lordship.
yes,
Administration to uphold the gift made by the government in favor of the petitioner's father.
Grievation-
From the top, because if I read from paragraph 3 onward, it is very clear, your lordship.
okay,
From paragraph 3 onwards, it is, the finding is very clear that it has devolved around the petitioner and the petitioner's father. The government has no issue with regard to that. So far as the chief secretary's letter is concerned, the court has made specific reference to 3 documents, your lordship. First is the special permit. Second is a memorandum issued by the circle officer in 1975.
where is,
Whereby-
where is that?
That is at page. Page 35. Page 34 is the original. Page 34. Since
Okay.
the special permit has been read over and over, I'm not going to go into that, but this is an up. This is.
35.
Yes, by this, your lordship will allow me to read.
Yes,
Whereas complaint has been received from GBS and ANGs, as well as public of Yongyu village and Sri Nokram Konya, Chief Ang of Chapuka village, the one which was being referred to by the United Government Advocate, and Sri Dingpong Konya. TV attached to the circle officer office. These have encroached the land allotted to let Wangshu Konya, and that means the petitioner's father. By this time, the petitioner's father was deceased, your lordship. Wangshu Konya at his headquarters, and now holding by his eldest son, Sri Lokman Konya, the petitioner. While the then additional deputy commissioner won special permit, memo number 8487 to 90, dated the 29th March 1971. Under the signature of Sri D.C.K. Lota, IA, the then ADC Mont, I have personally verified the boundaries and shown in the state permit with the help of Sri Piuwang Konya, TV, and Sri Achua Konya, TV, in presence of the state holder and the GPS and ANGs and publics of Jano village on 11 April 1975. And found bamboo groves, banana trees, stump of a dead tree, papaya trees, thrown prominently in the state boundary. Therefore, I do not find any reasons as to how Sri Nokzam Konyak and Sri Tingpong Konyak can claim the land by endorsement. I therefore uphold the special permit issued by the Erstwhile Additional Deputy Commissioner Home and further allow Sri Nokman Konyak, son of late Wangsu Konyak, to cultivate the whole plot of land as allotted to his father under the present care of Sri Zani Konyak, who is closely related to late Wangsu Konyak and resides at his headquarters. Since Sri Nokman Konyak is reading in school at Mon, but in no case Sri Zani K can claim ownership of the land. The one who has encroached, and even the other villagers, they have no right in short. Also, Sri Nokzam Konyak and Sri Tingpong K should stop encroaching the said plot of land immediately in order to avoid further complications. So this is the, after the petitioner's father expired, when encroachment and the villagers were making complaints against the petitioner land. Now, following this, representations were being made, nothing was done, so finally it came to the chief secretary, and the chief secretary, page 42, which I have read already. Now, subsequent, later on, since nothing was being, encroachments were made, government was making allotments. Finally, the matter reached the chief secretary. The chief secretary, the letter is very clear. The chief secretary has made it very clear. It was given to the petitioner's father because of his service to the state government. Here, it does not say that it is government land. The chief secretary is not making any claim that it can be taken away by the government at any time. The chief secretary is clearly saying the administration should honor what the previous administrations have done. You cannot do it. If there are encroachments, it is illegal. Conduct an inquiry. That means conduct to what extent the encroachments have been made and submit a report so that the chief secretary's office can take appropriate, pass appropriate orders to remedy the situation. This is what the chief secretary's letter says. The question of cancellation does not arise. There is no question of cancellation, Your Lordship, here. It is only to determine who has encroached to what extent, what the administration will now do. After determining the encroachments, then the chief secretary's office will pass appropriate orders.
Just
against
tell
the-
me whether for the cancellation of any land in a district, whether the approval of the government is necessary? Say, Chief Secretary.
The chief secretary was the one who allotted the land at that point of time in 1971.
No, it was DC.
Yes, he was at that point of time, the ADC. He knows the ground realities.
Oh, no, the Chief Secretary who has
Who
issued
has issued this
the letter, who was, he
Yes.
was Deputy
He
Commissioner
was
at
at
that.
that point of time, the additional deputy commissioner of
Okay,
Mon. So he had, on behalf of the government, granted the land to the petitioners.
hmm,
And now, finally, it came before, since no action was being done at the district level. And rampant encroachments were being made and the petitioner was a minor at that point of time. The question, he could not, he had no, and these small districts and all, they are backward areas, Your Lordship. They did not approach the court against that.
you challenge the cancellation order one, on what basis?
The this,
ground for challenging the
oh, my
cancellation
ground
order.
for,
Ah.
my ground for challenging the cancellation order is that it is against the, it is not in accordance with the chief secretary's letter and the high court's judgment. That is my ground. main
Okay.
ground. Because the chief secretary has not has made it very clear that it is now already his land. It is the land
Now
of,
my query is whether for the cancellation of the
yes,
special permit
Yes.
or the allotment of the lane,
yes.
whether the approval of the higher authority like
Yes,
chief
very
secretary is
much.
necessary.
Now-
Where do we find? Is there any?
Now the chief secretary's letter is very clear. Submit a report to me.
No, that is there.
Yes.
What I'm asking is there any rules or the lane,
There is
lane?
no particular rule, Your Honor.
Actually,
There is no particular law, but the only thing is that if the government wants land, now the government can acquire or requisition, land acquisition and requisition act is already there. Your Honor. Any land which the government requires, they may acquire and requisition. That is the only basis
Now
foundation.
my
on
query
which-
is
Yes,
because for getting allotment,
yes,
the district authority will forward it to the higher authority, lane
yes, yes,
commissioner.
yes. Normally that is done,
That is done.
yes,
So thereafter, after approval,
yes,
it will come back to district
yes,
and the district authority, the deputy commissioner will
Yes.
allot.
well alone.
So
But-
in the case here also, whether for cancellation, whether the approval of the higher,
Chief secretary was not done.
no, is necessary or not?
It is
What I'm
necessary
asking.
as per the judgment of this court. The judgment of this
No,
court
no.
has made it very clear.
No.
Yes, your lordship.
Hmm.
If this honorable court judgment is to be ignored, then that will not be appropriate because the court's majesty and dignity will be undermined. The court is going, this honorable court is going by the chief secretary's letter. This honorable court is going by the records that are available and the affidavit which has been filed by the state respondents. Affidavits are filed by the state respondents on oath. They are to be taken as there and based on this, once a judgment is passed by this honorable court, unless it is appealed against, it becomes final.
So where is it in the, where in the judgment?
Yes, now I'll take your lordship to the judgment. The petitioner has been pursuing this and by this 204 page 50, your lordship starts from page 50. This is dated 5/8/2014, your lordship. Here, your lordship starting from paragraph 3.
We have read earlier.
Yes,
So where the relevant portion where it says that land belongs to you, declaring the
Yes.
land.
I'll take your lordship to the specific portion, your lordship. Let me read the paragraph 3 because if I count the,
Okay.
so let me read the
Okay,
paragraph
okay.
3 because it is very clear in the paragraph 3. It is further case of the petitioner that after getting possession of the land, his father died, leaving the present petitioner as minor son. And taking opportunity of the same, some villagers, including one Tingpong Konyak and Nobzam Konyak, made encroachment in a part of the land. Situated thus, the petitioner submitted representation before the circle officer complaining of the encroachment. The circle officer held inquiry and thereupon prepared a memorandum on 11/4/1975, which is already referred to the lordship. This memorandum has been placed at Annexure C to the writ petition, which shows that after thorough inquiry, the jurisdictional circle officer arrived at findings that Tingpong Konyak and Nobzam Konyak have no claim over the land. The circle officer specifically stated that the land within the boundary was given to the petitioner's father in recognition of his service to the nation and hence nobody else than his heirs can stake claim over the said land. But unfortunately, thereafter, not only some private persons, but also some departments of the government elected intrusions in the land to the prejudice of the writ petitioner. The petitioner therefore submitted representation before the authority and ultimately it was taken up by the chief secretary for disposal on 18/7/1996. The order passed by the Chief Secretary on 18/7/1996 has been placed at Annexure F of his writ petition. In this order, the Chief Secretary has restated the facts as to demolition of the land on petitioner's father and thereafter on the writ petition. Devolution of the land on the petitioner's father and thereafter on the petitioner's father. It is now admitted, Your Lordship, by the Chief Secretary. And recognition of such special permit subsequently by the circle officer in the form of memorandum, which is annexed at Annexure B of the writ petition. Having so discussed the authentic facts and circumstances, the Chief Secretary was of the view that it is necessary for the administration to uphold the gift made by the government in favor of the petitioner's father.
These are your submission, huh?
Your Lordship, this is the finding of the court also. This is
No,
the finding
this
of
is
the
your
court. I'll-
submission.
I'll come to the later portion will verify it, Your Lordship. Now, the encroachment, if there be any, was found to be deprecated. To ascertain the correctness of or otherwise as to allegation of encroachment and quantum, allegation of encroachment and quantum of encroachment. Only the quantum of encroachment, okay, Your Lordship? Into the land in question, the Chief Secretary issued specific direction to the Deputy Commissioner Bond by order dated 18/7/1996 to hold a special inquiry and thereafter to submit detailed report as early as possible. The special report asked for as early as possible has not materialized even after efflux of 18 years of time till date. Now, the finding of this honorable court. Number 5. Paragraph 5. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, the circle officer prepared a memorandum on 11/4/1975, recognizing the same. If there is any encroachment, definitely, this is prejudicial to his legal and constitutional right, Your Lordship. This is the finding of the court. If there is any encroachment,
This is statement of the fact submitted by you.
no, Your Lordship, this is the finding.
Where?
Starting from paragraph 5 is the finding, Your Lordship, of this court. Yes.
Court said the
It
grievance
is
of the
very
petitioner.
simple. That is what he is saying.
Yes,
The
grievance
court
of the
is saying
petitioner
it
is simple.
Very simple, but if there is any encroachment, definitely this is prejudicial to his legal and constitutional right. It is not my submission, Your Lordship.
Yes.
It is the finding of the court. The Chief Secretary of the State, being aware of the situation, issued direction to the jurisdictional Deputy Commissioner way back on 18/7/1996. See, Your Lordship, paragraph 4, Your Lordship, it said, I have heard Mr. Subu Jamir, learned counsel for the petitioner, and Mr. K. Watsa,
Yes,
learned
stop.
senior government advocate, appearing for the state respondents. After that, only the finding of the court is coming, Your Lordship. It is not a submission of the court now that the court is again reiterating. The court is now coming to a conclusion here in this case. The Chief Secretary of the State, being aware of the situation, issued direction to the jurisdictional Deputy Commissioner way back on 18/7/1996 for holding special inquiry. There is no reason as to why the Deputy Commissioner would not hold a special inquiry as directed by the Chief Secretary. Although detailed report after such inquiry was supposed to have been submitted before the Chief Secretary as early as possible. But the proceeding went hibernating without any valid reason, depicting irresponsibility on the part of the district administration. In the process, a proceeding before the Chief Administrator of the state has been stalled. The proceeding before the Chief Secretary is being stalled because of the lack of the action by the Deputy Commissioner. Failure on the part of an authority in complying with direction of his superior not only betrays inefficiency of the administrative machinery of the state, but has also potential of sending wrong signal to the society. As to the rule of law, which is so sacrosanct in a democratic setup of grievance. This is the finding of the court, Your Lordship. This is not a submission of the petitioner. 6, although an affidavit in opposition, see, Your Lordship, this is opposition has been filed on behalf of official respondents. The claim of the writ petitioner has not been disputed, Your Lordship.
This is statement.
It has not been disputed. Now they cannot dispute it. It is now settled by this court. The fact as to issuance of direction by the Chief Secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Bond to hold special inquiry as was directed by the Chief Secretary by order dated 18/7/1996, within a period of 3 months from the date of receipt of certified copy of this order without fail, and forward the same to the Chief Secretary for passing necessary orders.
So this
It
is,
is for the Chief Secretary to pass the
Yes.
necessary orders, not any other officer. The Chief Secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of inquiry report from the Deputy Commissioner Mon. So the petitioner's statements, which is the same as made herein, about how he came into possession, how he came into ownership, this has not been disputed by the affidavit in opposition in the earlier case, Your Lordship. In this particular case, all the facts are admitted by the state respondents. That the petitioner's father has been granted it, the land now belongs to the petitioner, all those statements have been admitted by the state respondents in this judgment. This judgment has become final. If they want, if they are disputing this presently, then they ought to have filed an appeal with regard to the finding of the case. The facts are very clearly laid out. They have not disputed that. They cannot now say that, oh, the land actually was for this, and so we can take it away anytime. No, they cannot do that. They have acknowledged that it is mine. From the very date it was allotted to my father. In the earlier petition, the question of agitating that does not arise. Now, the court is placing emphasis on the Chief Secretary's direction, which is stated 18th of July 96.
so far as this
Yes,
order is concerned,
yes,
we have to see whether the direction of this court to inquire
yes,
has been complied or not.
yes. That inquiry was
And,
done.
yes,
Inquiry was done, and then it
And,
was
and,
submitted.
and also after
Yes.
inquiry, from the district, the inquiry report was to be submitted to the chief secretary.
Chief Secretary.
And then the chief secretary was to pass necessary.
Yes, that was
Or-
not done. That was hijacked by the
Hmm.
Deputy Commissioner and the Principal Secretary Home. The Principal Secretary Home is not a Chief Secretary. At the home level, they have taken the decision, all these inquiries, meetings were conducted, the petitioner was called for. This honorable court only directed that inquiry be conducted as per the direction of the Chief Secretary.
So the chief secretary was to pass necessary order.
Yes, and then the report. What was the nature?
The order,
of-
order, it appears clear that it was directed to chief secretary only.
Yes,
Yes, Your Lordship.
Although what learning council for the petitioner submits that is not there, but then
Yes,
the direction is clear
yes,
that the district, on receipt of the inquiry report from the district, it
Yes.
was chief secretary
yes,
who was required to pass an order.
correct, madam.
So,
I admit to that extent.
but here in the instant case,
Yes.
it appears that the commissioner of home,
Yes,
principal secretary,
yes.
he has passed an order.
No. This is where the
So,
dispute is,
just a
Your
minute,
Lordship.
where?
This is where the dispute is, Your Lordship.
So, just a minute, he has passed this capacity,
Yes.
in the capacity of, where is
Principal
the,
Secretary,
where is that impugn order? Para, page
page 83,
80?
83.
Principal secretary home, sorry.
Correct, madam.
Principal Secretary Home, he is not a Chief Secretary. He can.
No, he is not a chief secretary, Your Lordship. I agree, he is not a chief secretary.
The proceeding is before the Chief Secretary, Your Lord. It has been hijacked by these officers.
Regarding special permit.
Can I make a submission on this, my lord?
Yes, please,
Now, Your Lordship. This honorable court, in its judgment,
Hmm.
has stated that, if I may be allowed to read only that part,
yes.
I feel inclined to allow district director and deputy commissioner to hold inquiry as was directed by chief secretary from the date and from within a period of 3 months from the date of the receipt of the certified copy of this order and forward the same to the chief secretary for passing necessary orders. Now, Your Lordship, the next thing.
Yeah.
The chief secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of the inquiry report.
Yes.
Inquiry report. So the chief secretary is supposed to pass an order on the inquiry report. This impugn letter is not the inquiry report.
No, what is the DC's report?
Yes, the DC, the consequence of the inquiry report is the cancellation order. It's a cancellation order. Look at the impugn letter.
Yes, yes. Let us see the inquiry report. Let us see first inquiry report, then we'll come to cancellation. Let us see the inquiry report.
Inquiry report
Yes, yes,
relating to this,
yes.
this, your lordship.
Yes.
Page 24 of my affidavit in opposition filed in the WPC 58 of 2017.
Yes, page 24.
24, annexure 8. May I read, my lord?
Yes. No, no. Just a minute, huh?
Yes.
Yes, please.
Now, your lordship, see, to the Deputy Commissioner Mond, subject, special permit for farmland Tijit, dated 23/9/1971 to late
No, no.
Wanshu.
Just a minute. huh?
Yes.
When the direction was,
Direction was of the court was to pass an order with regards to the
This-
inquiry
this was-
report.
this was in the 5/8/2014.
Lordship,
5/8/2014. The direction of the High Court.
no, 204.
Where?
Yes, yeah, order dated 5/8/2014.
2014.
Correct.
On the, in compliance of the direction in this 5/8/2014,
Correct.
there was some inquiry report.
Yes.
Where is that inquiry report?
Inquiry report, your lordship will find it at page 58
Of the writ petition.
of the petition, my lord. No, page 55, my lord.
Yes,
Page 55.
yes, this I was looking at.
Page
So-
55.
Yes, and
Yes.
this report was submitted on which date?
This report was submitted to the additional chief secretary by the deputy commissioner Mond.
31st
No,
October.
no, 14th of November 2014 at page 64. Subject,
No.
submission of inquiry report.
No, initially it was submitted before the deputy commissioner.
Yes, and then the
The
deputy
month of
commissioner.
October,
Yes,
and on the same,
yes,
it was submitted to the additional chief secretary.
and commissioner. On 14th November.
Why additional chief secretary and not to the chief secretary? Because direction was to the chief secretary.
Your lordship, in fact, the commissioner Nagaland
Hmm.
heads the deputy commissioners of the districts. The commission, there's a post called Commissioner Nagaland
Yes,
who heads the deputy commissioners.
yes.
And therefore, the letter was addressed to him because.
So because the High Court direction was specific.
Yes,
Chief secretary.
yes. So maybe your lordship, this was supposed to be sent to the chief secretary.
Yes.
But since the commissioner Nagaland is the head of the deputy commissioners of a district.
No, the question of commissioner
Yes,
who heads the deputy commissioner of the district
Yes.
can arise here because it has to be as per the specific direction of the High Court.
yes. That part I agree. Your lordship. Yes,
So this was to the address to the additional.
yes,
My question is,
yes.
why to the additional chief secretary and why not to the chief secretary as per the direction of the High Court?
No, your lordship, as far as that part is concerned,
Ah.
that I have not said anything on my affidavit in reply. Affidavit in opposition.
So-
However,
Okay.
your lordship,
Okay,
however, your lordship.
Yes.
This court has directed the chief secretary to take a decision on the inquiry report.
Yes.
The impugn letter,
Hmm.
25 January 2020, is not a decision on the inquiry report.
No, let us finish this one.
Yes,
So this, on the basis of the direction, inquiry
Yes.
conducted.
Yes.
And the deputy commissioner submitted.
yes.
Okay, even, of course, not to the chief secretary, but an additional chief secretary.
Yes.
Then what is the result of the?
The result is, your lordship, the special permit was subsequently cancelled in lieu of it.
Okay.
Yes.
Let us see the cancellation order,
Page 80, annexure P,
page 80.
80.
So this is, this was the, page 80 was the result of the inquiry report.
Correct, my lord. This is the result
No,
of
no,
the
the
inquiry.
report was submitted on 2014 only. Report was submitted
Yes,
on November 2014.
correct,
And as per the direction of the High Court,
yes,
it was the chief secretary was to pass an order within 3
yes,
months,
yes,
within the period of 3 months.
yes,
The chief secretary for passing necessary order. The chief secretary shall pass necessary order within, 2 months
yes,
thereafter.
yes.
So, but then the cancellation order is after more than 4 years.
No,
That
what,
is 2018.
yes, what happened in between, your lordship, is that since the inquiry report,
Just this order, inquiry, on the basis of the inquiry report, what order the chief secretary has passed?
your lordship, one order the chief secretary has passed will be this order that is cancelling the,
No.
yeah,
My specific question,
yes,
because let us come back, 53 page,
yes,
come back to 53 of the writ petition.
yes,
The chief secretary shall pass necessary final order within 2 months thereafter from the date of receipt of inquiry report from the deputy commissioner.
correct,
Okay. Let
correct,
us see that deputy commissioner has submitted the report on 14th November 2014.
correct,
So thereafter, after 14,
yes,
within 2 months, chief secretary had to pass an order, necessary order.
yes.
Where is that order?
Well, your lordship, the within 2 months, the order could not be passed.
Okay, then
Yes,
when the order was passed by the chief secretary?
no, your lordship, any order, consequential order with in regards to this inquiry report is this cancellation order only.
No. Let us see whether, my specific question, please understand.
Yes,
Whether the chief secretary has passed any order after 2 months,
no, your
in
lordship,
2 months,
no.
that means
That-
the order has not, order was not complied with. Direction of the High Court.
As far as this particular order, consequential order, it should have been passed by the chief secretary. Your lordship, whether this order dated 24 September 2018, cancelling the special permit by the deputy commissioner.
This was not my.
No, this was done in permission.
Let us say, if it was not at the direction of the chief secretary, this is not connected with.
Yeah, that is what I'm saying. That's what I'm saying, your lordship. This was done on the direction of the chief secretary.
In the present case, it
Yeah.
was to be acted on the direction of the chief secretary only.
Correct.
Chief secretary was to acted on the direction of the High Court,
Correct.
whether that has been complied.
No, your lordship, there is nothing in the annexures as of now to show that whether that was,
Then that is to be complied first.
yes, whether
That is to be complied first.
lordship.
Thereafter, all these things comes, it appears.
No, your lordship. What happened thereafter? What happened thereafter?
Hmm.
This.
That appears immaterial.
Your lordship,
How it is material?
No, lordship, allow me to explain. Allow me to explain, your
Yeah.
lordship. How this letter 26 January 2020, all these things came into existence. It's not because the government did it themselves. It was because the petitioner approached us. It is not that the government did it on our own, your lordship.
No. So first of all, this was to be complied. Order of the High Court.
Lordship, there are two, three things.
Because whatever the petitioner
No, I agree.
or the respondent,
Yes.
deputy commissioner, whosoever may
Yes.
do,
Yes.
whatever
Yes,
in the meantime.
yes,
But then ultimately, unless this is complied with,
yes.
the chief secretary is yet to comply with.
Lordship, is that the only thing which is impugning this present writ petition?
No, that is what the chief secretary probably has not complied with.
Okay, it has not been complied
And
with.
then
Lordship.
subsequent order passed affecting his right. And
Yes.
probably that is why the order has.
Oh, that is why I'm saying, Your Lordship, if the chief secretary has not complied with this order,
Hmm.
is that the only thing that is impugning this in this writ petition? No.
Hmm.
The subsequent order also impugned.
Subsequent order passed by.
But by the principal secretary was also impugned.
Yes. But since it was affecting his right.
Why was it affecting his right, Your Lordship? Is because the petitioner approached us.
Because without complying, prior to compliance or compliance of the order and direction of the High Court,
Yes.
the order which
Yes.
is not connected was passed and which affected his right.
So, Your Lordship, if that is the case, then he should have challenged that alone, stating that all this consequential order has got no bearing. Has he done that? No. He is challenging all this consequential order. So if at all that submission is to be accepted, then this consequential order should not have any bearing. Why is he impugning it then? Why is he impugning it, Your Lordship, then? He is impugning it for the fact that these particular letters were issued at his instance. Can we deny that, Your Lordship? We have mentioned in our affidavit.
No, because just see, try and understand straight away.
Lordship, I understand that, Your Lordship.
Then how do we resolve with?
Lordship, therefore I say.
Because the compliance proper, not complied, and unless it is complied, then it still exists. The direction is still exists.
Lordship, that part.
Unless if you agree that it has not yet been complied.
Therefore I say again, Your Lordship.
Yourself admitted that this has not yet been complied.
Therefore I say again, if that is the case, why is he impugning the other consequential orders, Your Lordship?
No, the consequential order, it appears that in the meantime, so many things has come up and then.
How it come up? Because it is in sense of the petition.
That is why I was asking him that because of your.
How?
conduct,
Yes.
Because of the requirement and the conduct of the party on the part of the petitioner, probably this thing has come up.
Correct, Your Lordship, it is not so. It is all based on the special inquiry report.
Hmm.
After the special inquiry report, meetings were conducted by the district administration by the petitioner.
Hmm.
During that meeting, the petitioner has clearly laid out 5-6 demands. In those demands, the petitioner has also made a specific demand that a fresh survey be conducted also. Based on all this, they have conducted this. And in the meantime, without reaching the chief secretary's office, it has been hijacked by the Home Commissioner.
No, because it appears he is also right in the sense that you have participated in all these things.
Your Lordship,
You have participated and you have actively participated,
Whenever-
accepted,
yeah.
made a demand also.
because
and
the administration is asking him to come over. When he is asked, he has to submit his demands.
Now,
So-
while
Yes.
after all this
Yes.
also, entire happening of all these also,
Yes.
and you have come before this court, not saying this that not yet complied, and you have impugned all those things, those orders also.
But what I'm impugning is,
Hmm.
it is all stemming from the earlier complaint that was before the chief secretary
Hmm.
and the direction issued by this honorable court. His honorable court issued specific directions for inquiry, submission of report to the chief secretary. What happened was, without reaching the chief secretary, the deputy commissioner on the one hand issued the impugned order. That impugned order
Should have sticked on the.
what? Yes, so now,
Hmm.
if your lordship should, all these have its foundation in the inquiry which was directed to be conducted by this.
No.
Yes,
Not at all.
it was,
No, just one query from both sides.
yes.
Whether in the meantime or thereafter also, whether the chief secretary subsequently has passed any order.
No
in this-
order, no order.
No, Your Lordship, Chief
Any
Secretary.
query about that, because the direction of the chief secretary,
Yes,
it must have reached to the chief secretary also
Yes,
the order, the high court order,
yes,
whether
yes,
inquiring any letter
yes.
Yes.
The then chief secretary who was holding that post at that point of time, your lordship. I am not, today, as of today, I don't have any document to say concretely that his approval was taken.
His approval.
Yes, his approval was taken. That I cannot say concretely
Ah.
as of today because I don't have any document to that effect. But, your lordship, as far as the other impugned order is concerned, this is nothing to do with the honorable, of this honorable court order.
Yes, yes. That is why,
Yes,
yes, it was nothing to do with the.
yes,
order.
It
yes.
appears to be so, Your
It,
Lordship.
it appears to be so.
Yeah, it
Yes.
appears to be so, but it is not so. Unless the chief secretary passed.
But then
Unless the chief secretary.
during the
passed
subsistence of this order,
Yes.
could they have done?
Because the petitioner approached us. Because the petitioner approached us, your lordship.
No, they were the ones who initiated all.
No, not at all. He submitted a representation stating that he is ready to settle out of court.
Uh-huh.
And therefore the survey is conducted. It is at this instance.
Your Lordship, this representation.
And the impugned letter
Ah.
is on the basis of the survey that was conducted on the receipt of the representation from the petitioner.
Even
So it is at this instance, your
Your
lordship.
Lordship, even assuming, all right, if I have given for settlement outside the court, what was the so-called my submission before the authority? Have they complied with that? No, they ignored even those submissions. They have ignored everything.
We will not comply because substantial portion of the land was sold by him.
Now he had pointed out one point, the settlement out of court.
Correct.
Where do we find exactly? We have come across that order.
Survey report.
Let us see that.
25.
Your Lordship, my letter in here, in paper, annexure O also, here, Your Lordship.
Right.
I have not made any mention, annexure O, this is page 78, this is my prayer for settlement of dispute. I have written it to the chief secretary. See, Your Lordship, this is the letter to the chief secretary, and they have hijacked all this and then from the home secretary level, they are conducting all this. Annexure O, this is 2019.
Basing on this, whether the chief secretary has
No,
issued any order, any
no
direction?
orders. Your
Where is the direction that the chief secretary should pass an order on the survey report? Where is the direction of this court?
What is this argument? These are strange arguments being made here in this, before this honorable court.
Correct, your lordship. Very strange argument by the counsel for the petitioner.
Strange arguments. We are discussing about.
I agree.
Land which is mine, which has been allotted to me from the very beginning by the government. We are discussing about that. We are not discussing about another plot of land. This is the same land which is being discussed about.
So why is he impugning it then, your lordship? Why is he impugning it? If it's not at all aggrieved by, why is he impugning it?
Let him finish, let him finish. Submit, whatever you have, don't interrupt.
Why is he impugning it then, your lordship?
Come on, submit. Submit, and let me. make
Just a
the-
minute, just a minute, huh?
Let me make the argument after your turn.
So,
Finish up.
Definitely.
just a minute. There was two writ petition filed.
After this, two more writ petitions, after the judgment in the 2007, certain developments, certain orders were issued by the Tobashi's court, directing the allotments made by the petitioner to vacate. This being illegal, I have approached this honorable court by way of these two writ petitions. Those two writ petitions were against orders passed by the Tobashi's court, TB's court.
What happened to that?
The TBs, so that they have been stayed by this honorable court, it is still pending before this honorable court. There are other two cases. The
Okay,
earlier two cases are,
okay.
those are illegal in itself,
Okay,
it has to
okay.
be quashed and set aside, those orders are illegal in itself.
So,
But so far as this 88, the present case is concerned, this 88 is concerned, this is with regard to the subsequent orders which was passed cancelling the land which is in my possession, the special permit. So I am stating that it cannot be cancelled in any way, whether by the chief secretary or the deputy commissioner.
so it appears that your letter dated, the petitioner's letter dated
Yes, Without,
Here said,
since no action was taken, no action. was-
519
Yes,
is a reminder to
yes,
the court order passed earlier.
yes. And on the, and also reminding it that the chief secretary about the chief secretary about whereas, the special inquiry report also, Your Lordship. And even the last one, that is page 84 also, renegotiation of land dispute. Finally, after the home commissioner passed the imbued letter, this letter was submitted. Since the home commissioner took it upon himself to cancel the allotment in my favor, the petitioner submitted his representation after the imbued order has been passed. Imbued letter has been issued. So it is a case where the home department has hijacked the whole thing and then has been playing with it.
Not at all.
It has to be understood in that manner only, Your Lordship.
Then third issue about question.
Your Lordship may kindly come to my affidavit in opposition. This will clear everything.
Just a minute, 1 minute. Both the parties agree to. No, it appears that he has, by this letter also, he has reiterated to comply with the direction of the High Court.
Yes.
So where you says that the petitioner
Yes,
had wanted to settle the matter out of court.
yes.
Where do we find that?
There is no letter.
Para 5, page 5, para 2-1 of my affidavit in opposition, 58K of 2000.
Is para?
Para 2I, page 5.
Oh, no, this is there, but then where is the letter? Where he indicated that he want to settle the matter.
Your Lordship, the inquiry report itself is very clear that the total area claimed by L wants you to arrive at out of court settlement is 5.1
No,
acres.
no, where, I just, can you just show me where he indicated by
Yes.
writing or by?
Okay, Lordship,
Where his
Lordship.
signature also is there?
Lordship,
Yeah.
Lordship, if I cannot indicate that,
Yes.
is he disputing this fact that I have brought it before this honorable court? Is he disputing it?
Which one?
That he approached the government, as I mentioned in my para here, is he disputing this?
Para,
2I, yeah, 2I, page 5.
where do we find?
Lordship,
Can you just read this,
Yeah.
second portion?
five from the 1, 2, 3, 4, 5, 6, 7 from the bottom.
Okay, a report.
A report. A report was thereafter submitted that Sri L. Nogman Konyak is willing for settlement and closure of the matter. If besides allotting the land under physical occupations to him, the vacant field located behind his residence, which is a part of the land falling under the special permit, is also allotted to him. Is he refuting this?
So, have you filed
Your Lordship,
affidavit in reply?
This is a reply in 2017 case. Your Lordship.
Okay,
This is a
What-
reply in the 2017.
what have you
case.
said?
Correct.
In that case, I was not holding this petition at that point of time.
Your Lordship. Can that be a ground?
Your Lordship,
no, yes,
only in, this was.
No, because-
These no other petitions. were
because
filed.
unless you agree with,
No.
agree,
If Your Lordship may allow me to allow me to submit here. This is a this is in the 58 day of 2017, not in.
In
this
58?
instant case. In the instant petition, they have not filed any reply.
In the, I have filed,
It is
What?
not there.
I have filed, your lordship.
Where is that statement? Where is the affidavit? Where is the affidavit and where have you?
Your lordship, I have filed my affidavit on 13/3/2023.
Let us go by the affidavit which he has filed in the.
Why, your lordship? Why not take this affidavit to go? What is wrong? In order to suit him, he will take one affidavit, he will reject the other affidavit, your lordship.
To go by his reply in my instant petition, your lordship.
These are all his petition, my lord. The three-read petition belongs to the petitioner.
Let him finish, your lordship.
Hmm.
Young fellow, he has always been doing this with me.
Your lordship, he is the one who is interfering
Your lordship,
when I'm making my submission.
let
No,
him
no.
finish.
No. So
This
both
young
get,
fellow has been in all the cases.
no,
He has gone to the action of going outside of the courtroom. Quarreling with me. He
Your
has
lordship,
been-
that is a personal attack.
No,
He
no.
has been
No,
my,
yeah.
he was my earlier.
No, both will
He
get
is
equal opportunity.
listening
No.
all the time, your lordship.
Your lordship, I was reading this, he was interfering.
I am
That may not be required, that may not be
Let him
required.
submit.
Just, let us.
So allow me to submit then, my lord.
First,
Just, no, take a seat.
in this petition,
No, take a seat.
88, your lordship,
Hmm.
88,
Hmm.
where are those statements he has?
That
made?
is in the 58, that is in the 58.
Your lordship, no, in the paragraph,
No, that affidavit is in the 58.
no. The
No.
affidavit which he is calling into is in
In the 58 only, 58.
It's in 58, it's in
58,
58.
2017.
Yes.
your lordship.
Yes.
It is 58 day of 2007.
Correct.
Yes, there,
This is 88 of 2022 I am talking about. We are now,
88.
yes, we are now at 88 of 2022.
But you see, in the morning, so we are taking up entire matter together.
Your lordship,
Just a minute.
he is arguing about 88. He is
No.
arguing in this 88 on the basis of an affidavit filed in 58, which is a different fact. The fact is different, your lordship.
Your lordship, I'm arguing,
What is this?
I was basing this affidavit, 58, for the fact that the letter that is in 88, the letter dated
This is
26 January 2020, which is impugned.
preposterous. It is preposterous, your lordship.
No, just a minute. So this,
So according to him, should I not submit?
no, yeah, in the affidavit, in 88, have you said the same thing? In 88?
Your lordship,
Hmm.
the impugned order that is annexed in 88,
Yes,
impugned letter dated 25 January 2020, that is annexed in 88,
yes.
is the consequential letter of this survey report that I filed in 58.
No, why you did not file here?
Yes.
Your lordship,
58.
because I have already brought it before this honorable court in this 58, my lord.
No, supposing if we are taking 88, if it is not clubbed together, let us take it at each separate.
58, your lordship,
Hmm.
WPC 58,
Yeah.
WPC 207,
Hmm.
and WPC 88 relates to one and the same land. Filed by the same petitioner.
Here in the 88, have you filed reply?
No,
58, he has not filed any affidavit, your lordship, when he is arguing on the basis of the 50.
I have filed my affidavit on 13/3/2023.
Let us go by that affidavit. Let us go by that affidavit. Show me the affidavit.
So in this affidavit, you have not mentioned about that. In
Your
88.
lordship, whether he has.
Your lordship-
Or not, let us go.
Since I have already made a mention of it in the WPC
Wait,
58,
where?
in the WPC 58,
Hmm.
I have already brought it before the court
Hmm.
as to what transpires after the order cancelling the special permit was issued by the government of Nagaland. After that, what transpires? I have already brought it in the form of annexures and in the form of my statement. And the consequential order, which is included in the WPC 88, that is letter dated 26 January 2020, is the consequential of this survey report that I've annexed it in WPC 58 of 2017. Therefore, I was reading this, Your Lordship, 2I. Para 2I.
There are two I in, that is.
There is no para 2I in his affidavit.
Yes, there. No, in 58 it is there.
Yeah, but in 88, there is no para 2I.
88 it is not there.
Yes, it is.
So
admitted
now
or
he's basing on the affidavit filed in 58.
Yes. 58 cannot be taken as an affidavit filed in 88, Your Lordship. It is.
Should I be allowed to make my submission, Your Lordship?
Yes,
Because
please.
if I again intervene again, he is going to.
Yes, please, yes, please.
Yes.
Hmm.
Now, Your Lordship.
Hmm.
Kindly peruse the survey report, page 24 of my affidavit in opposition, filed in 58.
58,
Yes,
page 20.
24.
Now, what is submitting is submit based on the affidavit filed in 88.
Your Lordship,
Hmm.
the letter that is impugned in 88
Hmm.
is the consequential report
Could
of.
have annexed here. 88.
Your Lordship, I have already brought it before this honorable court by filing this.
Have you mentioned in your affidavit of, in 88?
Lordship, because
You have filed in 58?
no, the only thing that letter, letter 25 is impugned by the petitioner is only on the ground that the order passed by this honorable court in the WPC 204K of 2012, asking the chief secretary to pass an order on the special inquiry report has not been complied with. There is the only point I've mentioned as far as this impugned letter is concerned. Nothing more. Nothing more. They have not contested the things that are mentioned in this letter. The only ground that they have taken in proving this is only for the fact that it was not passed by the chief secretary. So I am submitting as to how this letter was issued by the principal secretary home is not in contravention passed by this honorable court in the WPC 204 of 2000. Because this impugned letter 25 January 2020 passed by the principal secretary home has got nothing to do with the inquiry report. I was there, my lord.
But then you see, earlier you submitted it was in continuation of that. In continuation of the direction. So now,
Not in continuation of the direction, your lordship.
okay,
Not in continuation of the direction. Your lordship, the survey report was conducted. The survey report was conducted because the petitioner, after cancellation of the special permit, has approached the state government with the terms and conditions as prescribed at part 2I of my affidavit in opposition, page 5.
yeah, just a minute. Huh? So this submission. The order passed by, you said that the order passed by the chief secretary, they dated, not chief secretary, principal secretary, home, is not connected with,
The special inquiry report.
okay, just a minute. Huh? Where is that? Hmm. Annexure Q. No, that you earlier submitted that in this annexure Q was consequence of upon the survey report of the survey report.
Yes,
And as per the direction of the direction in the WPC 2014.
your lordship.
Hmm.
Allow me to make only a short submission on this impugned order.
No, because it was on that direction only your submission we have recorded.
Yes.
Hmm.
See, my lord, what happened is this? What happened is this, your lordship?
Hmm.
The inquiry committee, special inquiry committee
Hmm.
has submitted its report.
Hmm. So now we are submitting that the order passed by the principal secretary home is nothing to do with the High Court direction in 2004.
No, not high court, not only high court direction, but it has got nothing to do with the special inquiry report.
Okay. It is also not based on inquiry report.
No, it has got nothing to do. It is not based on the inquiry report. And the High Court has directed the Chief Secretary to take a poll and to take a decision only on the inquiry report. Nothing more than that, madam.
But then during the subsistence of the order
Yes,
of the High Court
yes,
in 204 of
Yes.
2012,
yes.
could the home could the principal secretary home
Yes,
pass this order, this direction?
your lordship, Principal Secretary Home has not passed any order.
No, no, this direction. You
Which
will-
direction, my lord?
directing the DC to take immediate steps for taking action on all the points,
Yes,
because he has independently raised without if it is not connected with the direction of the High Court,
yes,
without, you see, linking into it. Or,
Yes.
without considering
yes,
that there was a direction of the High Court.
Yes.
Specifically to the Chief Secretary,
yes.
could he have give this kind of a direction to the independent direction to the Deputy Commissioner over the same land of the same dispute over the
Lordship, this is what I was trying to explain.
So he was based on the inquiry
Survey report.
inquiry report special inquiry report.
No,
of
survey report.
2014. No, he also mentioned special inquiry report. See, para 4.
No, your lordship, starting.
Hmm?
Let us start, the starting para. Please refer to the subject cited above and the letter dated 1st of February 2020 from the ADC Digit addressed to you. What is letter 1st of February 2020, your lordship? This is the survey report that I have annexed it in my affidavit.
Just see in para 4, as recommended in the special inquiry report 2014
Yes,
by a committee headed by ADC
yes,
of the same report,
yes,
talking of the same report.
your lordship.
Hmm.
As far as the other consequential things that are mentioned in the other paragraph,
Hmm.
it is very obvious that this particular statement was made in this letter based on the inquiry special survey report. Now, your lordship, how was this survey report conducted? I was on this line only, your lordship. How was the survey report conducted? Therefore, time and again, your lordship, in order to understand this impugned letter 25 January 2020, I have been reiterating and revisiting my affidavit in opposition file in 58 para 2I. For one last time, your lordship, allow me to read from the starting.
Yes, please.
Para 2I.
Para 2I.
Yes.
That we have read.
No, your lordship, I did not read the entire this thing.
Okay.
This will make
58.
58.
Just a minute. Huh?
Yes. I have read only the middle portion of it, your lordship.
Now, the Lana Council for the petitioner is insisting that the affidavit in 58
Yes.
cannot be taken as an affidavit in 88.
No, your lordship, why not? Because as again I'm saying, these are the consequential letter that was conducted, that has been brought on the special survey report. Now, what was this survey conducted, your lordship? I have explained it in.
Just simple question. For the purpose of, say, even if in other parts, can the affidavit in 58 can be taken in the as an affidavit in the 88?
Why, your lordship? Because in 88 they are impugning this, which is the consequential order of the survey report.
You had an occasion to give this statement or this averment in the 88 also. Why you did not then?
Your lordship, in 88, as I have stated, in 88.
Have you mentioned, referred that in 88 you have stated?
No, because why? Because, your lordship, in 88, they are impugning this letter only on the ground that it was not issued by the chief secretary. Nothing more.
Okay.
In fact, what should have been done is they should have impugned this survey report, because the survey report is what transpires in this letter dated 25 January 2020, which is impugned in 88.
Says that this survey report was not made available to them at that time.
Your lordship, as I mentioned, my affidavit in opposition of 58-17, which I have annexed the survey report, was filed on 2/3/2020. 2/3 of March 2020. I have not concealed this, your lordship. It is there on my affidavit as annexure 8, as one of the annexure in my affidavit in opposition. I have not concealed this.
It's also true. Just a minute, huh? It's also true because it was filed earlier. And
The fact is this.
and then by the time you filed this writ petition, it was already in existence. Could have
Whatever it is, but the inquiry report is of no consequence. Your Lordship. What is of consequence is the final order, because inquiry report can be.
No,
filed
they have also
anytime.
made, they have also made refer.
They are merely reports which are submitted, that the authority may or may not act on it, Your Lordship. These are mere recommendations. The ultimate order which is passed is the ultimate substantive order is the order which is passed by the appropriate authority. Based on the report, yes, but whether he has taken a reasonable decision or not, that question will be only raised against the order which was finally passed, Your Lordship. That is the position. Now, every petition has to be judged on the basis of the pleadings in every case, Your Lordship. You cannot bring a pleading from another case which is in existence and then use it in.
No,
one pleading.
now the question raised in your, according to the land council, for the respondent, the question raised in your writ petition
Yes.
did not allow him to bring that.
No.
Because you have
consider-
specifically raised few questions.
Your Lordship,
Specific,
I'll take your Lordship to the
Your impugn
specific
order,
paragraphs, specific paragraphs in
Hmm.
my petition. Page 18 onwards, Your Lordship. What he has replied here in this affidavit in 88. I am at 88 now, Your Lordship.
88.
Yes, we are dealing with the 88 of 2022 case. What is the affidavit he has filed here? That is the,
What he is saying is affidavit in 88 is in reply to the petition, writ petition
yes,
88.
yes.
And then he had no occasion, no space to bring this.
No, no, no. I am challenging that so-called letter which was issued on the basis of that so-called inquiry report. This is the survey report based on which this letter was passed. And what has it stated? This is annexed to my statement, and what is his reply here? He cannot bring in anything, Your Lordship. Your Lordship will see the annexed to. Paragraph 19, if your Lordship will go, if we start, because he has clubbed all this together and given a very short brief answer in this case. Now, paragraph 19, your Lordship,
19 of
of my petition, writ petition in 88. This is the imbued,
paragraph 19.
yeah, paragraph dealing with the imbued letter of the Home Commissioner.
19.
Yes.
Yes, what is that?
That subsequently, the Principal Secretary Home Department Nagaland issued letter number TAB 14 code 167 2019 51 dated 25/1/2020, addressed to the Deputy Commissioner Mon, pointing out and directing essentially inter alia that as per the detailed report of ADC visit, out of the 157.81 acres of land allotted to the petitioner's father, the petitioner has over a decade sold given 94.81 acres. The ADC visit has allotted to private individuals, organizations 42.4314 acres and land utilized for government departments, offices, and for roads and other public utilities like trains is just 16.928 acres. The land subsequently under actual possession of the petitioner is 0.67 acres, and the vacant land behind the house of the petitioner allotted by the ADC visit to 12 private individuals is 2012, for which the petitioner is asking settlement covers an area of 4.43 acres. That the petitioner has over the years already disposed of a substantial portion of the land without any intimation or consent of the government. Hence, it will not be proper to consider allotting any more land to the petitioner, that as recommended by the special inquiry report, the petitioner may be allotted only the land measuring 0.67 acres, which is under his actual possession, and in recognition of the services rendered by his father, concrete steps in the direction of building a school or public hall in the locality be named after the petitioner's father. That taking into account the present circumstances and the need to keep all the vacant plots for use by the government office or for taking up development activity that may come up in future. Immediate steps be taken for cancelling the allotment covering an area of 4.43 acres to 12 private individuals made by ADC visit. That plots not sold given by the petitioner be taken over by the government. That as regards the land allotted by the petitioner as proposed to be prepared and substituted for regularization sites allotments, and that action on similar lines may be also be taken for an area of 0.5171 acres, which is not vacant and over the years have been thought occupied by private individuals, organizations without being allotted by ADC visit or being so given by the petitioner. It is pertinent to mention here that a perusal of the imbued letter, particularly paragraph 3, reveals that the Principal Secretary Home did not even deem it necessary to endorse a copy of the same to the petitioner, and merely directed the Deputy Commissioner Mon to ask the ADC visit to convey to the petitioner that it will not be proper to consider allotting any more land to the petitioner, considering that the petitioner had over the years already disposed of a substantial portion of the land without any intimation or consent of the government. Such casual and nonchalant attitude on the part of a responsible officer of the stature of the Principal Secretary is not expected when his action and decision has serious implications on the very right to life of a citizen. Now, what is his reply, Your Lordship, in the affidavit which he has filed? That is paragraph 19, Your Lordship. Page 4, Your Lordship. Page 4. Page 4. Paragraph 13.
Para-
Paragraph 13, Your Lordship.
Hmm.
That as regards a statement made in paragraph 16, 18, and 19 of the writ petition, the same are matters of record, and therefore the answering deponent offers no comment. However, the statements that are contrary to and inconsistent with the records shall be deemed to be denied by the deponent. The record is admitted, Your Lordship. And paragraph 16, 18, and 19, if Your Lordship will go to the paragraph 16, 18, and 19, I am referring to the earlier inquiry reports that were being submitted. These are chronological orders. So he has clubbed together all those as facts, and it is very clear. He has not made out any to the fact that it is not based on the earlier reports. Now, Your Lordship, with regard to my submission, which is at paragraph 21 onwards, 21, Your Lordship, what is there to be done? Because here he has ample opportunity to mention that what he has submitted is the fact, and this is not so. Where paragraph 21 of my petition,
Yes. Hmm.
that the impugned special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020, on the face of it are patently arbitrary and unsustainable. This honorable court, by the judgment and order dated 5/8/2014, has clearly concluded that the claim of the petitioner regarding the special permit granted to the petitioner's father has not been disputed, and that the issuance of the order to the district administration by the chief secretary is also not disputed. And accordingly, directed the deputy commissioner Mom to conduct special inquiry as directed by the chief secretary by the order dated 18/7/1996, and to submit the report before the chief secretary for appropriate order. Now, Your Lordship, before I continue further, this impugned order dated 24/9/2018 is the deputy commissioner's order. Impugned order dated 25/1/2020 is the letter which has been conversed before Your Lordship, annexure Q, Your Lordship. Now, I'll continue. The order of the chief secretary dated 18/7/1996 is very clear that the administration had given the land to the petitioner's father in recognition of the assistance rendered by him to the administration, and also for standing for the people in times of difficulty, and that without his or his successor's consent, no land should have been allotted to any person or government department. The chief secretary also clearly enunciated that the administration should always honor the commitment given by previous administration to give its image in the eye of the people. The impugned order dated 24/9/2018 and the impugned letter dated 25/1/2020, that this is the one, are completely contrary to the order dated 18/7/1996 and the judgment and order dated 5/8/2014. From the judgment and order dated 5/8/2014, it is also obvious that this honorable court had directed the state respondents to take appropriate action to protect the rights of the petitioner and not to violate it. The issue involved in the matter was whether the petitioners complained that the administration was illegally issuing allotments in the land granted to the petitioner's father is true or not, and if true, to take remedial action on the matter. Therefore, the state respondents could not cancel the special permit under the facts and circumstances of the case. As such, the impugned special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020 are liable to be quashed and set aside. Your Lordship, now, he has answered this in one paragraph, paragraph 14, Your Lordship. Paragraph 14, because no amount of submissions, if it is not there in the pleadings, it is useless, Your Lordship. Paragraph 14. That as regards the statements made in paragraph 17, 20, and 21 of the writ petition, the answering deponent specifically states that in compliance with the judgment and order dated 5/8/2014 of this honorable court passed in WPC number 204 of 2012, a special inquiry committee was set up, which was headed by the additional deputy commissioner Digit, as chairman of the committee, and this committee has submitted its report on dated 31/10/2014 to the Deputy Commissioner Mon for onward submission to the Chief Secretary Government of Nagaland for passing necessary order as directed by this honorable court. This special inquiry report was submitted after several rounds of meetings, verifications, examinations of records relating to the case, and without the findings, the special permit though is authentic. However, there is no record of payment of revenue to the government. It was also stated that on physical verification, it is found that 111 numbers of permit was issued by the district administration. And it has been revealed that the petitioner, taking full advantage of the privilege given by the government to his father for a farm land, has sold out plots to 12 unidentified individuals by taking substantial amount of money. Further, it was also stated that due to this uncompromising stance between government and the petitioner, several individuals taking advantage of the situation has been occupying in more than 17 locations plots without any sanction from the government. The answering deponent further respectfully states that on careful perusal of the special permit which was issued to the petitioner, led further, it can be seen that this special permit was issued to late Shri L. Wangsu Konyak solely for farm land purpose only, which is very clear from the special permit number so-and-so dated 1971. Wherein it is categorically stated that Shri L. Wangsu Konyak RCM is allowed to continue cultivation of the low-lying areas which has put under petty cultivation at Digit. In the special permit, it was also stated that besides this area, he is also allowed to continue petty cultivation at the confluence of Digit and Dash has been shown in the map as Dash. Besides these two areas, he should vacate all the areas he has put under cultivation immediately. On bare perusal of these two lines from the special permit, it shows that this permit was issued by the government of Nagaland to the petitioner late father to continue with the cultivation on the government land at the areas mentioned in the special permit. And nowhere in the special permit is it mentioned that the areas specified in the permit are allotted to the petitioner late father. The petitioner, besides this special permit, has not annexed any valid documents showing that he owns the land or that the government of Nagaland has by an order allotted the area of land mentioned in the special permit in the name of his deceased father or in his name. It is to say that the petitioner taking advantage of this special permit has over the years disposed of a substantial portion of the land by selling to many private individuals, organizations without any intimation or consent of the government. The answering deponent further respectfully states that as regards the contention of the petitioner that the impugned letter dated 24/9/2018 and the impugned letter dated 25/1/2020 are completely contrary to the order dated 18/7/1996 and the judgment dated order dated 5/8/2014. It is to state that in both the letter dated 18/7/1996 and the judgment and order dated 5/8/2014 of this honorable court, a similar direction was issued to the Deputy Commissioner Mon to hold a special inquiry, and in compliance to this honorable court's order, a special inquiry committee was constituted and the order dated 24/9/2018, the letter dated 25/1/2020 was issued by the respondents, authority on the reports and findings of the special inquiry committee. And therefore, the contention made by the petitioner that this honorable court had directed the state respondents to take appropriate action to protect the rights of the petitioner and not to violate, and therefore the state respondents could not cancel special under the facts and circumstances of the case is false and whimsical and is therefore denied. Your Lordship, where is that statement which he is now trying to raise before this honorable court? And that 58, it is a case where I am not challenging this order. In that 58, during the pendency of the matter before decision of the Chief Secretary, this order was passed by the head TV directing the persons who were holding property to vacate the land. Against that, I had approached this honorable court to question, set aside that only. It has nothing to do with these orders which is challenged over here. These orders were not even passed at that point of time when I challenged that 58. That 58 cannot be used in this as an affidavit. When in this affidavit, they have not raised any such issues. There is no issue raised. They are just saying they are more or less only admitting what I have stated. Because specific denial should be there. They have not made any specific denial. They are not saying that these two orders are different. One is for this, the other is for this. Where is this statement here? It is not there. They are admitting that, yes, these orders were passed consequent to the special inquiry report. That is what they are stating here. And the learned government advocate is trying to present a different case, which is not there in the affidavit. And he is saying that it is the fact. What kind of what kind of submissions are these? What is the use of pleadings if they are not to be used at the time of hearing? This court has to go by the pleadings only. Had they made specific pleadings about those things in this petition, I would have submitted a reply. But they are more or less only going by my statements, Your Lordship. If Your Lordship sees that there is no statement in 15 also. As regards statements made in paragraph 22 of the writ petition, the answering deponent, while reiterating and reaffirming statements made in paragraph 14 of this affidavit, respectfully submits that from the perusal of the special permit dated 29/3/1971, which is the basis upon which the petitioner is claiming to be the owner of the land in question, is actually just a special permit given by the state government to the petitioner, deceased father, for cultivation purpose only. And in no point of time, the land was allotted to the petitioner, deceased father, or the ownership of the land was transferred in his name. The answering deponent further respectfully states that from the letter dated 25/1/2020, that means the impugned letter, Your Lordship, it is seen that the petitioner has over the years disposed of a substantial portion of the land, covering an area of 94.0195 acres to various individuals, organizations, which is about 60% of the total land, by utilizing this special permit issued by the government to his deceased father for the purpose of cultivation only, without any intimation or consent of the government, who is the actual owner of the land. And therefore, the contention of the petitioner that a special permit dated 29/3/1971 issued by the petitioner's father is a permanent land grant and cannot be cancelled at whims and fancies of the state government is out and out false and is totally misleading to this honorable court. The answering deponent also respectfully states that as with regards to the contention of the petitioner that in respect of the 111 numbers of permits, which was issued by the administration to settlers on the petitioner's land, a reasonable compensation should be paid to the petitioner by the respondent authorities. It is to state that the petitioner has no rights whatsoever to claim such a compensation, as the land in question was never allotted to his deceased father or to the petitioner by the government, and therefore, on the basis of a special permit given to his deceased father for cultivation purpose, only he cannot claim ownership over the land and seek such compensation. Where is that statement? Your Lordship, where is this so-called submission he is making here on the basis of the affidavit filed under 58? Now, 58, what is my case in 58, Your Lordship? Allow me to submit my case in 58. My case is, my prayer in this 58 is very simple. I have not challenged these subsequent orders which I am challenging here. I am challenging only some impugned orders, Your Lordship. Page 39. This is the order which I am impugning. Page 39.
Someone.
Yes, someone. A complaint letter had been received from Shri Zanai, President K. Abang, General Secretary on behalf of Morning Unit, District Town on 23rd March 2017 against Mr. Wangdon Konyak, Nedong Village for construction of building at Industry Ward. District Town, the said plot of land was already issued, allotted to Morning Unit, District Town, wide permit number so and so. In this connection, all concerned artists is a someone, Your Lordship. No, the order is the next one, Your Lordship. This is what I am agreed with. With reference to a order dated 13 April 2017, with reference to a complaint letter dated 23/3/2017, received from Monian Union, District Town against Mr. Wangdun Konyak of Nidong Village for construction of house at the allotted site of Monian Union, District Town. In this connection, the TV's court visits summoned both parties to appear before the TV's court. along with site permits on 13 April 2017. The Ammonia Union TZ Town produced site permit by number so and so, whereas Mr. Wangdong Konya could not produce the site permit. Therefore, the TV score TZ to hereby direct to Mr. Wangdong Konya of Nidong Village to vacate the house and remove the materials from the same site land on or before 13th May of 2017, within 1 month from the date of issue of this order. This is a completely different order. This has nothing to do with that, with the case in 88. This is, yes, facts. Facts with regard to the judgment of this honorable court in 2004 and the earlier allotment and the letter of the chief secretary is also there. But apart from that, I'm only asking that this order is not legal, question set aside. So in this, he has filed an affidavit. He has filed an affidavit, and I am not aggrieved with that in this petition. In this petition, I am not aggrieved at all. It was only after this was filed in 2017, your lordship. In 2022 only, I filed it. This was filed by my learned colleague one, Mr. Supu Jamil. These two cases, your lordship. This case I filed, but subsequently he asked me, the petitioner asked me that since Mr. Supu Jamil is unable to take up his cases, to handle this case often. After we filed it, so we took it over, your lordship. But whatever it is, this has nothing to do with that which he is submitting. And in this petition, he has to give specific reply saying that, oh no, this letter dated 25/1/2020 is completely a different issue then. But he is not denying it. He is admitting what I'm stating by not replying to it directly. If there is denial, he has to deny specifically, your lordship. Where is this specific denial here in his reply? And he is trying to bulldoze this honorable court by making submissions which are not there in his affidavit. The purpose of having pleadings is to help this honorable court at a fair and just decision by way of specific pleadings by both the parties. You cannot submit, and learned counsel cannot submit what is not there in his pleadings, your lordship. His pleadings are completely different, and he is making a completely different submission, and he is saying that this is legitimate. What kind of submission is that?
Yes. Yes, anything?
Yes. My learned friend is talking about the pleadings, your lordship.
Yes.
If that is the case, where in the pleading in the writ petition has he stated that this impugn letter besides that it was not issued by the Chief Secretary of the State, the content of this impugn letter is wrong. Where has he mentioned that? And therefore, earlier also I was submitting this. He was stating only, he was impugning this only on the ground that it was not issued by the Chief Secretary. And therefore, it is in violations of the order passed by this Honorable Court in WPC 204K of 2012. This is his pleadings, your lordship, and I'm going by his pleadings only. Where, your lordship? He's referring to para 21, your lordship. Wherein para 21 has he stated that this particular letter is wrong or illegal. Only that, your lordship, it was not passed by the honorable passed by the Chief Secretary, your lordship. Shall I allow me to read para 21, your lordship?
21 or?
Of the WPC 88, your lordship.
Yes, yes. He just read. You want to read?
Yes, your lordship.
Okay.
He has mentioned the letter here, the impugn letter here, your lordship. The special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020 on the face of it are patently arbitrary and unsustainable. The Honorable Court, by the judgment and order dated 5/8/2014, has clearly concluded that the claim of the petitioner regarding the special permit granted to the petitioner's father has not been disputed, and the issuance of the order of the district to the district administration by the chief secretary is also not disputed, and accordingly directed the deputy commissioner Mon to conduct a special inquiry as directed by the chief secretary by the order dated 18/7/1996, and to submit the report before the chief secretary for appropriate order. The order of the chief secretary dated 18/7/1996 is very clear that the administration has also given the land to the petitioner's father in recognition of the assistance rendered by him to the administration and also for standing for the people in times of difficulty, and that without his assent or successor consent, no land should have been allotted to any person or government department. The chief secretary also clearly initiated that the administration should always honor the commitment given by the previous administration to keep its image in the eyes of the people. The impugned order dated 24/9/2018 and the impugned letter 25/1/2020 are completely contrary to the order dated 18/7/1996 and the judgment and order 5/8/2014. From the judgment and order 5/8 it is obvious that this honorable court has directed the state respondent to take appropriate action to protect the rights of the petitioner and not to violate it. The issue involved in the matter was whether the petitioner complained that the administration was illegally issuing allotment to the land granted to the petitioner's father is true or not, and if true, to take remedial actions on the matter. Therefore, the state respondent could not have cancelled a special permit under the facts and circumstances of the case. As such, the impugned special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020 are liable to be questioned, set aside. Where, Your Lordship? Your Lordship, para 23. The impugned special inquiry report dated 31/10/2014, and the impugned order dated 24/9/2018, and the impugned letter dated 25/1/2020 are unjustifiable, utterly arbitrary and unreasonable, and in clear violations of the petitioner's right to life. Naming a school or a public hold in the name of the petitioner's father will not fit the petitioner's family. By cancelling the special permit, the respondents in one fell swoop to have taken away the only means of livelihood for the petitioners and his family. The state action being clearly in violation of the petitioner's fundamental right to life, the impugned special inquiry report dated 31/10/2014, the impugned order dated 24/9/2018, and the impugned letter dated 5/1/2020 are unacceptable and liable to be quashed and set aside. Where, Your Lordship? Paragraph 24. That when a judgment and order dated 5/8/2014 in the WPC 204K of 2012 specifically directed upon receipt of the special inquiry report of the Deputy Commissioner Mon, the Chief Secretary shall pass necessary final orders within 2 months. The Chief Secretary could not have delegated the duty imposed upon him by the Honorable Court to the Principal Secretary Home, Nagaland, and the Deputy Commissioner Mon, as has been done in the instant case. The Chief Secretary has no other, the Chief Secretary and no other can pass a final order in the light of the Honorable Court order. The instant case is a classic case of abdications of power. The impugned order dated 24/9/2018 issued by the Deputy Commissioner Mon, and the impugned letter dated 25/1/2020 issued by the Principal Secretary Home, being issued by unauthorized officials, are void ab initio and liable to be questioned and set aside. Where? These are the reason, Your Lordship. These are the reason. These are the reason why we are saying, Your Lordship, this impugned order is the consequential of the survey report that we have placed it before this Honorable Court, which is also clearly mentioned in the impugned order letter itself. Whatever is incorporated, Your Lordship, in this special inquiry report that I have annexed in WPC 58 in my affidavit in opposition is again reiterated here, and the decision as such has been taken, Your Lordship. Now, not only that, Your Lordship, the petitioner was also fully aware that the petitioner allotment of a land was given to him by an order dated 25 February 2020 by the deputy commissioner. That is done in compliance to this particular impugned order. Impugned letter, your lordship. And when did the petitioner file, your lordship? This instant repetition. It was filed on 19/5/2022. The petitioner was already in possession of the documents. Yet, when he filed this writ petition, the WPC 88 of 2022, he has not challenged this. He has not raised those things, your lordship, as now he is trying to project. And this, your lordship, this letter, 25 January 2020, issued by the principal secretary, is not in contravention of the order passed by this honorable court. Because this is not a letter that was issued by the principal secretary to the deputy commissioner Mount to comply. It did not come out from the special inquiry report. This was a special survey report done, your lordship, at the instance of the petitioner submitting a representation to the government to settle the matter out of the court.
Where is that letter you said?
Your lordship, I've already, that is why I'm saying, your lordship,
Sir.
yes, that is why I'm saying, your lordship. If at all, your lordship, he has some problems with it, he should have contested here. Has he given his reply, your lordship? No.
No. Here in this, your reply also, that has not been pointed out, that on the basis of the petition made by the petitioner,
Yes.
or the representation made by the petitioner, it was settled. Have you stated in?
That was never brought before this honorable court in the WPC 88. That is what I've been mentioning, my lord. It was never brought before the notice of this court. Your lordship, why I'm saying this over and over again.
Then the order has been challenged. But the
The order has not been challenged.
order has been impugned.
Yeah, the order has not been challenged. The letter has been challenged.
Sorry, the letter has been impugned.
Challenged. And
You said that that letter is outcome of that representation by the petitioner.
yes. After the
Yeah,
cancellation,
Here you had an occasion to annex here in this affidavit.
your lordship, we have already brought it before this knowledge of this honorable court as well as to the petitioner by filing this.
But you have not referred here also that you have stated in that 87.
Your lordship, because that issue was never raised, that issue was
Yeah.
never.
But then what, supposing that has not been dealt with, can we base on that?
Why not, your lordship? Because it is one and the same land. One and the same land, your lordship. It is one and the same land, your
But the
lordship.
challenge there is altogether to the different impugned order.
Your lordship, the challenge made there,
Hmm.
the challenge made there was a permit was issued by the government to the private respondent, to which the petitioner has challenged. That was the thing, your lordship. That was the thing. But your lordship, in that process, we have filed an affidavit, bring it on record. Everything here, your lordship. So when the writ petition WPC 88 was
Now,
filed,
Here, dealing with this petition also, this 88 also,
yes,
and probably that will not be there, these 58 and others will not be dealt with together. Because even if they pass negative or positive,
yes.
that will say in view of the order passing here. But then for the purpose of disposal of this writ petition, we cannot base on the documents based on, you have submitted.
No, we cannot base on that,
Yeah.
your lordship. We cannot base on
That
that.
is what I'm
So,
saying.
so taking that into consideration, your lordship, the petitioner should have raised those things in WPC 88. What he is saying is that this is impugned purely because it was passed by the principal secretary and not the chief secretary. And therefore, this is in contravention of the judgment passed by the honorable court. Which I said no. Because the judgment passed by the
I
honorable
will
court.
again say that here you had an occasion to raise that this letter by the commissioner commissioner is based on the representation submitted by the petitioner. You had an occasion to.
Your
bring it
lordship.
to that.
Your lordship, this is why I have been submitting.
Hmm.
If you read the
Hmm.
first para of this impugned letter,
Hmm.
it clearly reflects that this was passed in pursuance to this survey report. It's clearly reflected here, Your Lordship. It's clearly reflected. So the decision, this decision was passed by the Principal Secretary, taking this survey report into consideration. So has the survey report been challenged by the petition and this writ petition? No. So I was not given an occasion to say that. That has been my submission, Your Lordship. Look, Your Lordship. Look at the para. What is being mentioned here? If I may be allowed to read only the first para. Para 1, page 81.
Yes.
See, Your Lordship, please refer to the subject cited above and the letter dated 1st of February 2020 from ADC Digit addressed to you with regards to the status of the entire land under the special permit as is existed on today, and another letter dated 8th of January 2020 from ADC Digit addressed to you, mentioning the meeting district L Nombang Wansha for settlement of the entire dispute concerning the aforesaid land. Your Lordship, see, in between, Your Lordship, I'll show you.
Meeting.
Your Lordship, please, Your Lordship may kindly come to para 5. Para 5. Para 5.
Para 5.
Yes, page 82. Further, in public interest and taken into account the present circumstances and it exists in town, in Teji town, all vacant plot tracts of land falling under the special permit need to be kept for the use of by any government office or for taking up any development activities that may come in the future. Hence, you may take immediate steps for cancelling the allotment covers an area of 4.43 acres. This is what the petitioner was claiming. To 12 private individuals made by ADC Digit in the year 2012, which is consolidated tracts of the land at one place and mentioned, see, Your Lordship, and mentioned at serial number 4 in the ADC Digit dated 1 February 2020 and taken under the custody of the government. See, Your Lordship. Even here also it is clearly reflecting the survey report. Not only that, Your Lordship, it is again mentioned at para 6. It is again mentioned at para 6, Your Lordship. See, that the vacant plot not sold given to the private individuals by Sri L. Nogman Wanshu Konyak or elected through any permit by ADC Digit, as well as those plots sold given to private individuals by Sri L. Nogman Wanshu Konyak but vacant, mentioned at serial number 10 and 8 of the report of the ADC Digit dated 1 February 2020, which measures 7.9035 acres may also be taken over by the government. In all these cases, proper allotment order in a manner as considered appropriate by you may be made so that there is absolute clarity and that this tract of land belongs to the government.
Now he is taking a different, you see, just a minute. Huh?
Lordship.
Just a minute. So you must have understood by now.
I have understood it.
And then what do you say about this in the para 1, first paragraph, which is
It contradicts.
referred.
Yes, it contradicts a statement made in paragraph 17 of his affidavit, Your Lordship. Paragraph 17 of his affidavit, he has been reading about my
No,
paragraph 24.
just
Yes.
first let's read
Yes,
the paragraph 1.
yes.
You just read for yourself. So say here, there is a mention of meeting with Mr. So-and-so, your petitioner, for settlement.
Paragraph 1,
Of page 81 of your petition, please come.
yes, this was
Kindly see especially the line,
page 81, Your Lordship.
yes, page 81 of your petition, Q,
Yes.
annexure Q.
One. Yeah.
The first paragraph, first
It
paragraph,
has reflected it, yes. Your
yes,
Lordship.
reflected it.
Now it is paid, I was not part of this thing, Sir Lordship, but whatever it is, he has decided on the basis of the inquiry, special inquiry report. It is admitted in his petition, in his in his reply, Your Lordship. In his
No,
reply
no.
itself, he has admitted.
So here you have understood that this mentioning the meeting with Sri L. Lokman Wangsu Konyak for settlement
Yes,
of the entire dispute,
yes,
mentioning the meetings with the petitioner.
yes.
And then say the Konyak for settlement of the entire dispute concerning the aforesaid. So it appears that you approached,
No, Your
and
Lordship,
that is why he is submitting
Your Lordship,
that it is not connected with the other.
whatever approach was there is on record. Already.
Hmm,
It is on record.
hmm.
They may have
Now-
made some mention.
Now,
here
yeah,
and there,
yeah,
but-
see, the
but
line
not
of his
on-
argument now, you
Yes.
see,
Yes,
now you could have seen that line of argument, not on the basis of the what
Yes.
you have your basis of your pleadings, but then his pleadings different.
that is what he has said.
That the impugn order
Yes,
is not connected with
that is
that.
what they are saying.
And
But
this is because subsequently you approached for settlement out of court. Try to understand, this is going different way.
that is what he is submitting.
Yes,
But his statements in the petition says otherwise. Your Lordship. That is the only saying I'm saying.
but if you have understood, if you have understood this one,
Yeah,
kindly,
yeah.
please.
Paragraph 17, Your Lordship.
17 of
Affidavit, Your Lordship. Affidavit. Paragraph
the
17.
government affidavit,
Yes, his affidavit.
paragraph.
Paragraph 17, page 9. This is, he has read about my,
This one. Page 9, para 17, yes.
Your Lordship.
Hmm. Yes,
That as regards the statement made in paragraph 24 of the writ petition, the answering deponent respectfully states that in compliance with the judgment and order of this honorable court, the government of Nagaland, on receipt of the special inquiry report, has took a decision on the matter, and the same was communicated to the deputy commissioner Mon by the principal secretary Home Nagaland, while later dated 25/1/2020.
now you,
Your Lordship, what is this? What is
just
this?
a minute, huh? Both are mixed up. Your line of argument is different. And then the pleadings again different, it's very complicated.
Lordship, then,
It's developing years.
yes,
Ah,
then my
one
line
has
of,
to stick on to.
yes, my
the
other line of
pleadings,
argument
ah.
is if whatever is stated in my affidavit is to be accepted and taken into consideration in disposing of this writ petition, then my line of argument in my affidavit is that, Your Lordship, that the land was donated by Jabaka village to the government. The government has given a special permit to the petitioner's father. The land was never allotted to the petitioner's father, and therefore the land still belongs to the government. I've mentioned that in my paragraph 16. So take that into consideration,
That,
that the land
But-
belongs to me. Now
but-
I have canceled the special.
but
permit.
that, if you take that, then you see the lane, this court
Yes,
by 2012 petition,
yes,
204, 2014, says that it appears
Yes.
that land was given to, and it is his land,
yes,
which is not disputed.
yes,
And then asking the
yes,
chief secretary
yes.
to
Pass an order.
pass an order,
Yes.
get a report and pass an order.
Yes, yes.
So then that will come.
No, Your Lordship, then in that case, what about the letter? Because the decision has been given in the letter and has already been complied with by allotting 0.65 acres of land to the petitioner.
No, that is not, see how it is connected then. Because the chief secretary has not yet passed any order on the basis of the report submitted by the deputy commissioner.
Your Lordship, see,
Hmm.
not only the petitioner,
Hmm.
not only the petitioner, but even the government also here.
Hmm.
We are trying to be very careful in actually disposing of the land disputes.
Hmm.
That is why, Your Lordship, even in my submission, I have admitted before my Lord that before any decision was taken by the government on the special inquiry report, a rounds of talks was held with the petitioner, wherein the petitioner has put forward certain demands,
Hmm.
which has been annexed in this writ petition.
No, see, tries crossing two line of argument.
Yes,
You says, one way you says that the disposal, cancellation,
yes,
and then this impugn order is nothing to do with the High Court direction.
No,
Now again in your affidavit, you says in person to,
lordship, actually, yes,
Hmm.
that,
So
that,
then-
yes,
in person to.
yes.
So then this is a contradictory submission.
Lordship,
Contradictory
yes,
submission.
yes. However,
So now,
yeah,
now you see, now while saying that, while saying in your affidavit, keep it, your submission.
yes,
So then it is on the basis of the direction of this honorable court in the earlier 204, 2014.
yes,
So if it is on the basis of the direction of this court,
yes,
and on the basis of the direction of the court, the DC has submitted report to
Yes.
the additional chief secretary,
yes,
and then the chief secretary has not yet passed order. I'll repeat it again
yes,
at the cost of course, repetition.
lordship,
So this is there.
yes,
And then
Correct.
now you are taking another view,
yes,
another line of argument saying that it is nothing to do with that.
no,
If it is nothing to do with then, there also, you see, one thing you have to remember. There also you have to see that if in existence of the order of the
Yes.
order and direction of this court,
yes,
can the authority pass order? Your only the only your shelter is that he has come before you
yes,
for settlement. Settlement.
yes, yes,
So, but then while taking that shelter also, you again come back that on the basis of the direction of the High Court.
lordship, what
Hmm.
happened is like this.
Hmm.
The direction of the High Court was to take a court on the special inquiry report.
Hmm.
The report was submitted.
Hmm.
Basing on the report, the permit granted to the petitioner's father was cancelled. It was basing on that report, the permit was cancelled. Now, what happens after that is, your lordship, after the cancellation of the permit, the petitioner re-approached us again.
Now, where is that document?
Your lordship, I have mentioned that, this is why.
That reference.
Yes. And that part, your lordship, the petitioner is not refuting it at all. And they have come and approached the response department with their representation to settle the matter out of the court. And therefore, in order to settle the matter out of the court,
Just a minute, you have not clarified this, that the settlement, you approached the authority for settlement. They are repeatedly saying that you approach out of settlement, out of court settlement, if it comes, then even despite of direction of any court, that can come. That can come into.
Even it can be sent for mediation also.
Yes, yes,
It can be
mediation
sent for
also. So
mediation.
they are repeatedly they are
This
saying.
repeated statement which he is making,
In
it has no relevance to this.
no, in the impugn order also, impugn order also, we have referred.
But his statement is, this is a statement made by the officer, your lordship. He is making a statement which is not made by the officer in this court. This is the officer, they normally, whenever petitions are filed, it has to be sent to the state respondents. All right, this is the petition, you submit your parawise comments and then let us make this.
No,
This
that's
statement-
fine. Okay, let us see, they have made this statement. What do you
Yes.
say about the out of court settlement proposed by you to the government?
No action was taken, your lordship, even after this, even after the.
No, just come back to that, the impugn order. Come back to your impugn order once, just once. Reference, I referred, the meeting with you. So you have not, this meeting, this appears, from this it appears that really it may not be connected with that, not in person with the direction of this court.
No, it is, my specific statement is that it is connected with that. They are saying that, yes, that is the case, your lordship. My statement in the petition all along is that these are all connected to the High Court's order and the decision to be made by the chief secretary. That is my consistent statement, your lordship, in my petition. And they are admitting that. They are admitting in the affidavit, whereas in his submission, it is contrary to the admission in the affidavit. Your lordship, if your lordship will read my petition, it is consistently my case.
What is this?
That paragraph 24 also mentioned, I have made it very specific in the paragraph 24 which I have replied here. Oh,
So
these are.
there is some defect in your petition also. Your pagination, correct it, huh?
Yes, your lordship.
Correct it. And then there's 85 also, just abruptly it jumped 85, nothing, no beginning, nothing, huh? Your 80, can you see it once, just show him once, huh? From 82, just show him. once. It will be difficult, carrying it home for judge, it will be difficult to locate. 82. Last.
Oh, 82 is.
And then thereafter also come page 85 also, come to page 85 also. 85, where is the beginning? Beginning of that letter.
Yes, your lordship, allow me to insert appropriate page.
There you have to do.
Yes, yes.
It will be difficult.
Allow, your lordship, allow me, I'll make it as 85A, your lordship, so that.
85 doesn't have any beginning. Where is the
Yes,
beginning?
the beginning page, I'll. 84, this is the letter to the, by the petitioner. This is the,
And then the pagination also
yes,
different.
I'll make it, oh, 83. Your lordship, allow me to make the necessary corrections. Allow me to.
Okay.
Yes. Wait, after.
So your submission still remains. 10 minutes. But now time off. I think because I thought that the line of argument was clear, but then in the last moment, line of argument changed. And then you see the argument of thought also completely changed again. So the line of thought on the case also changed. So probably you may, of course, give some this one also the point, which may bring us back again to the track. So and then he also need to correct, because even if I have to carry it as a CAB,
Yes.
then this pagination with this pagination I will confuse. So you correct it.
Yes.
Yeah. So what we'll do
Your
is
lordship may pass appropriate notice that we can do the correction with
okay.
the. for the
Okay.
register.
So last one day we'll keep. Then thereafter I'll pass order. No
Lordship.
clarification.
Yes.
But more or less we have understood. But then both of you are, of course, you know, but then try to confuse me.
It is.
Anyway.
In a different.
Like a hard 88, huh? Mr. Tongpok, Pongner, Land Council for the petitioners, the petitioner only, huh? Only one petitioner, petitioner, stop. Also had Mr. Enangami, Land Government Advocate for the state respondents, respondent number 1 to 4.
Yes, madam. 1 to 4.
Stop. And Miss Apila Sanktam, Land Council for the respondent number 6.
Yes, yes.
Okay, that is in 58, huh? Okay, stop, huh? Clara. At this stage, after hearing for some, at length, comma, Land Council for the petitioner. Then at this stage, Land Council for the petitioner prays for allowing him to correct the pagination and the annexures. Correct the pagination in so this have you seen the 85, this one? 85, there is no beginning. Beginning you have to
Yes,
insert.
yes, yes. I'll insert. Page 85, that letter
Later, because there is no beginning, we do not know. No idea, but then it's not complete. The beginning page is not there. The annexure, huh? Annexure and pagination. The prayer is allowed. The petitioner, the prayer is allowed, huh? The registry to do the needful.
Your Lordship.
Of the stuff, huh? Least is matter again on when do we fix? Thursday? Thursday. Thursday as a part hard matter, huh? Okay. Just a minute. In earlier occasions, I have made some notes regarding the submission of the petitioner. It is not found. It is here. Staple it, huh? Staple it and keep it here only. Some matter takes longer time. In a case, it takes some days together also.
Yes, and very
Let us
sorry
be
that
clear first.
our emotions took over us and then maybe some unreleased scenes has been witnessed, my lord. Extremely sorry, my lord.